Good morning, members of the Joint Judiciary Committee. It is wonderful to see you here on this first meeting of our interim. This is the first meeting of a new Joint Judiciary Committee, and we are excited to be together for all the work that we're going to accomplish this joint interim. And with my co-chair, Chairman Jared Olson, welcome, Co-Chairman Olson. It is great to have you and to bring such a strong team with you as we start the work of the interim. Senate Judiciary Committee, here we go. Your first interim for most of you. I hope you enjoy it and are ready for the ride. We have a lot of great work to do to advance Wyoming on the issues in the judicial branch. And so with that, we will start with a roll call.
Senator Cooper. Here. Senator French. Here. Senator Kolb. Present. Senator Cost. Here. Representative Crago. Here. Representative Larson. Here. Representative Oakley. Here. Representative Provenza. Here. Representative Washut. Here. Representative Williams. Here. Representative Yen. Here. Representative Zwanitzer. Here. Chairman Olson. Here. Chairman Nethercott. Here. All present. Chairman Nethercott.
All right, thank you, Mr. Fuller. Wonderful to have LSO here with us live as well, and great to be staffed by our favorite Mr. Fuller, who has been a primary LSO staff attorney on the Judiciary Committee, who just does excellent work for us. And the team at the table over there is responsible for organizing and providing the materials for this agenda. And so incredible work to the team who has really worked hard this year and during this interim. Committee members, it is the history of the Joint Judiciary Committee that the House Chairman chairs the first day, and we will continue with that practice. As a reminder to all the members, we are co-chairman, and so you may refer to us as co-chairman and our names. I know there's always also hesitation and confusion for what to call me. I am comfortable with you referring to me as co-chairman, Madam Chair, Chairman. It's all fine and it will work fine. So feel comfortable with however you choose to address me as chairman. I will understand that you are speaking to me. Our first order of business, as I turn it over to the House Chairman, will be our adoption of our Joint Judiciary Committee rules. Committee members, you have a copy of those. They're listed on the website and should be a hard copy available for you to review.
Thank you, Co-Chairman Nethercott. I also want to thank PBS who is recording and streaming this broadcast for us. Do we want any presentation of the rules, or are we satisfied just reviewing them? Brian, let's have a brief explanation of the rules, if you would, please.
Yep, sure thing, Mr. Chairman. So these rules are virtually identical for those members of the committee who were on the Joint Judiciary Committee during the last legislature. These rules will be identical. And there are three primary changes from the sample rules as both houses adopted them during the 2021 general session. First is just a change to reference co-chairman rather than a chairman and a vice chairman. The second change is just noting that one chairman presides over each day of the meeting. And then on the second page, this is the primary change. It would be section 2D, where it describes quorum. And this just provides that a quorum necessary to conduct business is a majority of the members of the entire joint committee. And then a majority of the quorum can act on any matter except to vote to sponsor a bill as a committee bill for that kind of final vote before the bill would be introduced. That requires a majority vote of the quorum of members of each house then present. Mr. Chairman, as long as I've been here, that has been the practice of this committee, is to have the voting by each house. And that's really the primary change from those sample rules. With that, Mr. Chairman, I'm happy to answer questions.
Thanks, Brian. Committee question, Representative Zwanitzer.
Thank you, Mr. Chairman. Mr. Fuller, how many other committees abide by that rule of a majority quorum from each body right now?
Mr. Chairman, Representative Zwanitzer, right now, I am unaware of any other committee that has adopted those. There may be committees that have, but I'm not sure if any others right now have adopted that.
Representative Larson.
Mr. Chairman, I know the Ag Committee passed a similar one where it had to pass both chambers to bring a bill forward.
Mr. Co-Chair. Thanks, Mr. Co-Chair. It's been the history of the Judiciary Committee since I've been in the Senate on a member of this committee that it requires a majority vote of a quorum of each member of each chamber to pass and sponsor legislation. The primary purpose of that really is efficiency. If one chamber won't pass it, it's likely to not pass also the chamber in actual session. And so it is a matter of just utility and efficiency. Most of the time it works. Sometimes it's problematic, but it has been the longstanding history of the Judiciary Committee, at least for the last 5 to 6 years. I can speak to. Regarding the quorum necessary to transact business, some of this is just logistical challenges that I've experienced associated with some of the Senate members having only 5. It can be a challenge, and it's important that just because maybe we have a couple of that are arriving late or needing to leave early, that we can still get work done regardless of their attendance with a majority of the joint committee available. So that's some of the rationale for these rules. And so the historical precedent of the rule of the Judiciary Committee, and then just some practical sidebars associated with being able to move forward with the business of the day.
Co-Chairman Nethercott, I would add to that. I know one committee that has this as a longstanding rule, this process, is the Appropriations Committee. And because I served on the Appropriations Committee, and what I found it useful for exactly what you referenced. If you don't have buy-in from both bodies on a bill at the end of this long interim, then if, the entire House, say, for example, wanted a piece of legislation and we didn't have buy-in from the Senate, I feel like we would definitely waste our time during the session. So I think it's an effort to make sure that we're a little more cohesive when we come out so that we can work together to get the same goals during the session. And I did find that it worked really well with appropriations. Any other discussion? Not, I would entertain a motion to adopt these rules. Okay, it's moved by Representative Larson and seconded by Senator Cost. All those in favor signify by saying aye. Aye. All those opposed? No. Those rules are adopted. All right, now that we got that out of the way, we can get to some substance. And the first topic on our agenda is juvenile justice. We're going to begin this topic with an LSO summary. And Mr. Fuller, is that you presenting for us?
That
Or a
is, Mr.
combination?
Chairman.
Okay.
Would you like me there or here?
Wherever you're comfortable. It looks like the cameras are doing just fine over there. Whatever
Okay.
you'd like to do.
I'll just jump in right here then. So, Mr. Chairman, members of the committee, Brian Fuller, LSO. This will just be a quick overview of the topic summary on juvenile justice. Most of this summary focuses on the Juvenile Justice Act. And I'll also briefly mention the CHINS Act as well toward the end. I'll cover a few areas like jurisdiction fees, which, Mr. Chairman, you had identified as possible points of consideration, as well as diversion programs and multidisciplinary teams. So just, I guess, as a broad overview, the Juvenile Justice Act states as a purpose that there's a focus on rehabilitation for juveniles who commit delinquent acts while acknowledging the concept of punishment. The act is to provide for the child's best interests as well as the protection of the public. The Wyoming Supreme Court has noted that by enacting a separate juvenile code, the legislature has recognized that juveniles aren't similarly situated as adults, where goals are for the juveniles are focused on both rehabilitation and protection and not necessarily punishment. The process for an adjudication of an alleged delinquent act, which is an act that would be punishable as a criminal offense under Wyoming law, but does not include status offenses. Status offenses are those that if an adult committed them, they would not be a crime. So the way this would start, a petition is filed and an order to appear is issued to the child and the parents. The act provides that a child may be taken into immediate custody if there's a risk that the child or minor may abscond, or if it is necessary for the child's health or welfare, or the welfare and health of others. Taking a child or a minor into custody without a court order is limited to circumstances where arrest could be made without a warrant, where a child or minor is violating a court order, or where the child's conduct seriously endangers him or herself or others. The juvenile court must ensure the parent's presence at any hearing, and the juvenile court may appoint a guardian ad litem or counsel to represent the child. The court would then order the Department of Family Services to prepare a predisposition study and a report that would cover various aspects of the child's background, history, and environment. And then the court would appoint a multidisciplinary team, which I'll go into more detail about those in a little bit. An initial hearing is then held where the court can proceed to evidence on the petition or set a later time within 60 days for an adjudication hearing. An adjudication hearing may proceed with a jury if it's demanded. That hearing, the act provides that it's held in an informal but orderly manner, and the district attorney must present evidence in support of that petition, and any allegations of a delinquent act must be proven beyond a reasonable doubt. After the hearing, if the court finds that the allegations are not proven, the petition must be dismissed. If the allegations are proven, then the court must enter a decree and state the jurisdictional facts on which the decree is based. And then the court can proceed immediately with disposition of the minor or delay that for 60 days. For deciding on a disposition for a minor, the court must review the predisposition report, any report and recommendations from the multidisciplinary team, as well as any other reports that the court is ordered to be prepared. The court can impose any sanction that's authorized in the Juvenile Justice Act, but out of state placements. So if a child is to be sent to a facility that's located outside of Wyoming, those require additional findings on behalf of the court. Generally that, an in-state placement would not be appropriate. The sanction levels that are available under the Juvenile Justice Act are specified. They're broken into levels that are based on the seriousness of the act that forms the basis for the child's delinquent conduct. And there are limits on the sanctions that can be imposed based on those levels that are in the statutes. If a child is removed from the home, the agency or institution where the child is placed must submit periodic reports to the court and recommend if placement should continue. And then the court must conduct a formal review periodically to determine the continued appropriateness of that placement. A disposition once entered remains in force for an indefinite period until either the court terminates the order, if the purpose has been achieved and it's in the child's best interest to do so, or if the child reaches age 21. The juvenile court can also hold proceedings on revocation of probation, contempt for either the child or the parent's liability for failing to exercise the parental control or authority of the child. The juvenile court is able to hold proceedings for those matters as well. To get into the juvenile court, the jurisdiction is a little bit split. A child can be tried or have their proceedings go through juvenile court, through district court, through municipal court. The district attorney is considered the single point of entry for the juvenile in terms of what court that juvenile or minor may proceed under. The juvenile courts, they're established in statute, and the district judges serve as juvenile judges. The juvenile courts are courts of limited jurisdiction. So that means they only have the powers and the ability to hear certain cases as the legislature expressly confers. So the juvenile courts have exclusive jurisdiction for cases where minors are younger than 13. If that minor is accused of committing an offense or a delinquent act, that would be a felony or a misdemeanor that's punishable by more than 6 months. For all other matters, the juvenile court has concurrent jurisdiction. And so this means that a juvenile can be sent to juvenile court for their case to proceed, or to district or circuit court as the delinquent act may dictate. And again, it would be the district attorney who would determine the appropriate disposition of that minor accused of a delinquent act. The juvenile court can also, coincident with proceedings for minors that are alleged to be delinquent, the juvenile court can determine custody issues for the minor. The juvenile court can order any party to the proceedings to perform any acts or responsibilities, as well as order any party to refrain from an action or conduct that's detrimental to the minor's best interests. All cases where the juvenile court has concurrent jurisdiction must start in the juvenile court, but can be transferred to district court after a hearing. So the Wyoming Supreme Court has held, in terms of jurisdiction, they have noted that there is no constitutional right to be tried as a juvenile. It is a privilege that is granted by the legislature and can be amended or changed by the legislature, so long as the legislature doesn't act in an arbitrary or discriminatory manner in delineating the jurisdiction of the juvenile court. With that, Mr. Chairman, before I move on to the next topic, I'm happy to answer any questions about jurisdiction.
Committee, questions about anything that we've talked about so far? Representative Zornitzer?
Thanks, Mr. Chairman. Just some questions on when you say juvenile court, does every county have a juvenile court? And who are the judges that make up a juvenile court, and how are those the same or different than a circuit or district court?
Mr. Fuller?
Yep. Mr. Chairman, juvenile courts are in each county, and Representative Zornitzer, in terms of the judges, the statute provides that the district judges serve as the judges of the juvenile court.
Mr. Fuller, on page 4, I'm looking at your second bullet point, and this reminds me of a conversation I had with Representative Provenza recently. It says the juvenile court must ensure the parents present at any hearings. Is there a statutory or maybe case law pertaining to the presence of a parent during questioning of a juvenile? I'm assuming it's not statutory, otherwise you probably would have covered it in this memo.
Yep. Mr. Chairman, I'm not aware of the Juvenile Act mentioning parents' presence during any sort of questioning. And I'd have to look into the case law a little more for that answer.
Okay, I think we'd be curious about the answer to that. Thanks, Mr. Fuller.
Mhm. Okay, Mr. Chairman, then moving on, for diversion programs, the Juvenile Justice Act actually does not specify any procedure or requirements for establishing or using a diversion program. Several counties have established diversion programs that are operated through various entities. Some, for example, in this county, Natrona County, I believe there is a team that's put together consisting of law enforcement, family services, the courts, the district attorney, who participate in determining if a juvenile should be diverted, if they're alleged to have committed a delinquent act. There are also some that, under the Community Juvenile Services Act, which I'll discuss in a couple of minutes, have established community juvenile services boards, which have established diversion programs. Other counties have programs where the district attorney, in line with the statute, manages that program and determines if a juvenile should be diverted from an offense. For multidisciplinary teams, this is included in the statutes for the Juvenile Justice Act. And a juvenile court is required to appoint a multidisciplinary team within 10 days after a petition is filed. Statute provides who must be on that team: the child's parents, a representative from the child's school district, a representative from the Department of Family Services, the child's psychiatrist or psychologist, the district attorney or a designee, the child's attorney or guardian ad litem, a volunteer lay advocate, and a foster parent. The juvenile court can also appoint other members to the team as it sees fit. And these discretionary members include the child, a relative of the child, a representative from the Department of Health with particular expertise in substance abuse and mental health issues, as well as other professionals who may have particular knowledge of the child that may be beneficial to the work of the team. Before the multidisciplinary team meets, Department of Family Services must prepare a summary of the case and the allegations that have been levied against the minor. At the first team meeting, the team must develop reasonable and attainable recommendations for the court that outline goals and objectives that parents must meet for the child to return or remain in the home, or for the case to be otherwise closed. At subsequent meetings, this team is required to review the parents' and child's progress and reevaluate the plan that it previously developed. It must form and amend written recommendations to submit to the juvenile court, and then a coordinator prepares summaries of those meetings as well. Statute refers to the coordinator only, I think, once or twice, doesn't specify who the coordinator of the team is. So I assume it could be any member who is on that multidisciplinary team. If a child, if the disposition of a case involving a child results in the child being placed outside of the home, the multidisciplinary team continues to meet quarterly to review the progress, as well as develop any new recommendations for the child. And then before a dispositional hearing is held, I think I mentioned, sorry, the team must provide the juvenile court with a report and recommendations for the child's disposition.
Mr. Fuller, this is a total side question, but can we get someone to adjust the air in this building? Seems warm, little extra warm. It's actually the main reason I became a chairman, is so I could control the temperature in the room.
Nope.
Thank you, PBS.
What is it now? Okay.
That concerns me on where it was before that. Aha. Mr. Fuller,
Yes.
please proceed.
Thank you, Mr. Chairman. Mr. Chairman, I'll move on now to fees that are required under the Juvenile Justice Act. There is no fee for filing a petition or service of process. In some cases, the act provides that the parents of the child may be responsible for some of the costs that are associated with a proceeding or a petition under the Juvenile Justice Act. The act actually notes that legal services are necessities for which the child's parents may be held responsible. If the court determines that the child's parents can pay part or all of the costs, the parents may be charged for those services or costs that are provided as part of a proceeding. The court may also order that parents reimburse counties for other fees, including witness fees, travel expenses, the cost of service of process or notice by certified mail, the cost of any examinations for the child, as well as other costs of proceedings that would be accessible as costs if the case were held in district court. When a child is placed on probation, the court must determine whether the child or parents can pay part or all of the expenses of probation. And if so, the court is required to order reimbursement of those costs. Similar for if a child is placed in custody in a facility or otherwise. The court must inquire into the family's financial situation and then order the parents to pay a reasonable sum for the support and treatment of the child based on the presumptive child support amounts that are specified in statute. And then certain expenses and costs under the act are charged to counties where the proceeding is held. And that would be like the witness fees, the jury fees and costs, services, examination, counsel, and any other costs that would be accessible in district court. Now, Mr. Chairman, I'll move on to data collection. The act provides, I would say, in fairly discrete places, requirements for the collection of data involving juveniles in the justice system. These include the Interstate Commission for Juveniles, There's a statutory requirement for the collection of standardized data concerning the interstate movement of juveniles, and that's data the commission must collect. There's also the State Advisory Council on Juvenile Justice. I believe you'll hear from them a little later. One of their statutory duties is to assist communities to collect, compile, and distribute data that's relating to juvenile justice, including an inventory of programs and services that are available in each county. The county sheriffs are required under statute to report, and the Department of Family Services is required to analyze data regarding the application of certain juvenile detention risk assessment instruments. The Division of Criminal Investigation is required to create and maintain a database for a juvenile justice information system and report to this committee on that database. And then the final statutory requirement that we could find pertaining to juvenile justice is that the court is required to direct that data in any case where a child is adjudicated as delinquent is collected and provided to DCI, to the Division of Criminal Investigation. We also found, in terms of voluntary data reporting, the Community Juvenile Services Board submit data to the State Advisory Council, data from the 4 juvenile detention centers in the state. And then there's also data that's collected by the state coordinator under the Prison Rape Elimination Act regarding that data. The Wyoming Supreme Court also collects data and reports aggregate data regarding actions filed under the Juvenile Justice Act and CHINS Act. And the Department of Family Services also provides various data. One of the meeting materials, I believe it's 2-05, is a report from 2019 that the Management Audit Committee, that LSO staff for that committee prepared for management audit. And they had, I believe they were undertaking a program evaluation of CHIN's actions and juvenile outcomes associated with those minors who are subject to CHIN's actions, so children who are needing supervision. That report noted various concerns, and those are on pages 8 and 9 in terms of the challenges that staff faced with trying to complete a program evaluation when compiling data from various agencies, different agencies using different systems, different identifiers for minors. My good colleague, Ms. Creech, just informed me that's 2-08. So I gave the wrong number, so my apologies on that. So it's 208 in that. And as a result of the challenges with the data, the Management Audit Committee was not able to complete that program evaluation. But that report does outline those challenges that were faced with that. This committee looked at juvenile justice data back in 2013. I didn't notice any sort of legislation that was enacted as a result of that. And then research revealed 2 other laws, one from 2004 that provided a reporting requirement for the Department of Education concerning court-ordered placements and any educational expenses incurred or funds that are provided to those children who are placed in facilities. And then in 2008, the Department of Family Services was required to report to this committee on the juvenile justice boards receiving funds and the scope of services and cost of services that those boards provide. Then moving on, Mr. Chairman, to community juvenile services boards. This is Title 14, Chapter 6, Article 9, I believe, of that act. And these boards were established or created to establish and maintain and promote the development of juvenile services in Wyoming communities, focusing on early identification and diversion of children at risk, and allowing decisions regarding juvenile services to be made at the local level. This initially started as a pilot program in statute. When the act was when the legislature first enacted the Community Juvenile Services Act, there was a block grant account that was created and an appropriation, I believe of $2 million was the initial appropriation for counties to create these community juvenile services boards. Statute specifies who must be on these boards if a county creates it. It includes DFS representatives, local public health officials, school officials, district attorneys, law enforcement, county commissioners, mental health or substance abuse treatment providers, the public defender, and any other professionals who may be interested. The act also allows the Board of County Commissioners to create a juvenile advisory board who can advise the county commissioners on juvenile justice issues. There's a process for applying for grants that these juvenile services boards can apply for grants. At last count that I had, there are 14 current boards, community juvenile services boards, 3 of which are joint powers boards and 1 of which is an advisory board. And then I believe, Mr. Chairman, with the recent budget that was enacted, funding for those grants is eliminated, I believe, starting July 1. And then finally, Mr. Chairman, I'll just briefly summarize the CHENS Act, the Children in Need of Supervision Act, was enacted in 1997. And the CHENS proceedings are virtually identical to the Juvenile Justice Act. Most of the language is quite similar. The CHENS Act focuses on children who are in need of protective supervision, probation, or other services. And children in need of supervision are defined as those who are habitually truant, or who have run away from home, or habitually disobey reasonable and lawful demands of parents. Similar to the Juvenile Justice Act, under the CHENS Act, there's concurrent jurisdiction between the district court and the juvenile court. Complaints of children who are in need of supervision are referred to the district attorney, who must determine whether the best interests of the child require action to be taken under this act. If a child's adjudged in need of supervision, similar to the Juvenile Justice Act, the court must review the predisposition report, the recommendations of a multidisciplinary team, and then the court must ensure before making a disposition that the Department of Family Services has made reasonable efforts to prevent or eliminate the need for the child to be removed from the home. And if the child is found to be in need of supervision, the court can allow the child to remain in custody of the parents under protective supervision. So conditions placed on the child's actions and behavior. The court can transfer temporary legal custody to a relative or other suitable adult, or transfer temporary custody to the state or to an agency for placement. Orders under the CHENS Act terminate at 18 or sooner if a court determines, but if a child is still in custody of the Department of Family Services at 18, services can be provided to that person on a case-by-case basis. With that, Mr. Chairman, I'm happy to answer any questions.
Committee, Representative Yin.
Thank you, Mr. Co-Chairman. So thank you, Mr. Fuller, for that outline. I think it's really useful. Do you know if, I don't know if you sent this to us before, but have you sent that report from the Management Audit Committee to the Joint Judiciary Committee?
Yeah,
Okay.
Mr. Chairman, Representative Yin, it should be in the meeting materials that were mailed out.
Great, thank you. And
It's published online as well.
great, and I will look that up, and I hope everyone does too. Mr. Co-Chairman, Mr. Fuller, I think it's interesting that the district attorney is the sole entry point for determining which court is chosen for any particular allegation. Do you know if there's a statutory requirement for the district attorney to justify based on his list of objective requirements to determine which court for any particular case?
Mr. Fuller.
Yep. Mr. Chairman, Representative Yin. So I'm not, other than the statute saying the district attorney shall establish objective criteria, screening, and assessment procedures for determining the court for appropriate disposition. I'm unaware if there's anything else in here in the act that says what those must be.
Thank you, Mr. Co-Chairman. Follow up?
Please.
Mr. Co-Chairman, Mr. Fuller. So I appreciate that. So then I'm just curious, is there a way to determine, to follow up for any particular allegation on any individual minor, what the justification between choosing one court or another after the fact.
Mr. Fuller.
Yep, Mr. Chairman, Representative Yen, and I'll allow, I'm sure others who will come after me, will correct me if I'm mistaken on this, but the statute, the starting point is the juvenile court. And then I believe there has to be a transfer, there has to be a motion to transfer that proceeding to district court. I assume at which point, as part of that process, the district attorney, I'm not sure if there's a requirement for the DA to provide reasons 1, 2, and 3 why that must be transferred, but a hearing is held. So the child can be heard through counsel or guardian ad litem in terms of countering any reasons that may be provided for that transfer to district court.
Thank you, Mr. Chairman. I look forward to learning more about the process. Thank you.
Committee, other questions? Representative Provenza.
Thank you, Mr. Co-Chairman, and thank you, Mr. Fuller. Do you come across a minimum age of culpability or the minimum age in which a child can be charged with a crime in the Juvenile Service Act?
Mr. Fuller.
Yep, Mr. Chairman, Representative Provenza. My recollection is the only kind of clear age reference is age 13. Anything under age 13 belongs to the juvenile court. I'm not sure there's a minimum age for a minor to be brought.
Is that the same with the chins? Because I think you're referencing page 7 where you say concurrent jurisdiction does not extend to minors who are younger than 13. So then that means everything under could just be juvenile court, right? And then everything above may be juvenile court, or we'll call it regular court. And then what about chins? That's the same?
Mr. Chairman, I don't believe there is a separate age distinction for the chins for that delineation of jurisdiction.
Co-chairman, another comment?
Thanks, Mr. Co-Chairman, and members of the committee. These are great questions. Keep them coming. A couple of reminders, and to the folks sitting in the audience, and that might be online, if you could jot down some of these questions. I know some of you have a great deal of subject matter expertise associated with the ability to answer these questions. If you don't voluntarily answer them, I will ask them of you again when you come forward, or ask you to come forward. So just embrace it however you might. And to the members of the Joint Judiciary Committee, there are 2 prosecutors on this committee, and we are grateful for your expertise. It is a little awkward sometimes as a committee member to provide additional information when it's appropriately directed at LSO, but Representative Crago, Representative Oakley, information for the committee to have to make appropriate decisions. Don't be shy. Representative Crago, Representative Oakley.
Oh, with each of those questions, I looked to Representative Crago to see if he was going to reach for the mic, but he wasn't interested. Representative Oakley.
Thank you, Mr. Chair. I don't know if now is the appropriate time. I saw Judge Christensen back there kind of ready to answer, I think. So I think maybe we did get things a little bit wrong. I don't think anything too, what was I thinking? Oh, the transfer. Depending on the crime, like a felony crime, they can be charged as an adult originally, and then the defense attorney can bring a request for a hearing, and we do a transfer hearing at that point where we go through the factors. So there is a way, and it happens sometimes, where the choice is made originally to charge quote unquote as an adult. I don't like that phrase, because what does that mean? But where it would originate in a criminal court proceeding, that does exist.
Representative Oakley, just so I'm understanding the committee's understanding, you are talking about anyone who's over 13 that may be charged with a crime and not in juvenile court.
Mr. Chair, that's correct. So I can think of one, it was sexual abuse of a minor in the first degree. So 16-year-old with a 4-year-old victim. So I started, for example, charging as a felony, and then we did, so it immediately is filed in the circuit court to go to the district court to be held as a, to proceed as a criminal matter. And then the defense attorney did a motion for a transfer hearing, and then you do the hearing where the judge decides whether it would be transferred to juvenile court or stay in criminal court. And for your information on that one, the case did proceed as a criminal matter in the district court.
Commit further questions? Mr. Fuller, do you have more?
Mr. Chairman, just to add to Representative Oakley's statement, and I can clarify, cases can be filed in the act delineates the cases that can be filed in either court. And those are certain municipal ordinances, all misdemeanors except those that are within the juvenile court's exclusive jurisdiction. Felony cases where a minor is 17, cases where a minor is at least 14 and is accused or charged with a violent felony. And then cases where a minor is 14, charged with a felony and has previously been adjudicated as a delinquent under 2 separate juvenile actions.
And Mr. Fuller, just for the committee, that's page 8 of your memo, right? The bottom, the second half of that page has a nice bullet point list of concurrently crimes that may be commenced either in juvenile court or in district court or inferior court. So I think that's the list you're reading off, and maybe that will help the committee a little, because there are, as you just pointed out, there are actually some different ages depending on what the crime is, it looks like. So, okay. All right, Mr. Fuller, was that the conclusion of your presentation?
It is, Mr. Chairman.
We have a separate memo on the service board funding.
Yeah, Mr. Chairman, and that was the information I covered earlier.
Okay, you did talk about the board.
Yes, Mr. Chairman.
Just to clarify, you said that to your knowledge, there were 14 current boards. And you said something after that, there were some joint powers boards and advisory boards. What was the breakdown of that?
Yep, Mr. Chairman, by my count, I had three juvenile boards who were formed as joint powers boards and one as the juvenile advisory board. That's an option that's provided under the Community Juvenile Services Act.
And you also said that the block grant ends on July 1 under the current budget.
Mr. Chairman, that's my understanding.
Is that in the Department of Health's budget, do you know, by chance? Or is that in, I know that we have DOC here, but I think that's probably, oh, it's DFS, which is quasi Department of Health. Okay, so we can talk more about that when we get Corin. Okay. All right, nothing further from LSL. We'll move down our list now to, I think we want to go to our Council on State Governments. Is that right, Mr. Fuller?
That's right, Mr. Chairman. They're appearing via Zoom, so we'll get them logged in here.
Okay.
Good morning, committee. Good morning, Chairman Olson, Chairman Nethercutt. It's nice to be with you.
Yes, thanks for joining us.
Definitely. My name is Stephanie Duryea. I'm a senior policy analyst with Council of State Governments Justice Center, and I was the state lead in the last months of our JR efforts, justice reinvestment efforts in the state. So it's a pleasure to be here with you today. I know JR is slightly different than the juvenile justice topic that you guys are all considering today, so I hope you don't mind a quick derailment here as I provide you all with a brief summary of JR as it has wrapped up in the state of Wyoming. And I also want to thank the committee for allowing us to appear via Zoom this morning as we are not cleared for travel yet here at CSG Justice Center. So I appreciate the accommodation there. I am going to go ahead and share my screen with the committee, if that works for everybody, as soon as I am able to from the host. While we're doing that, I also want to recognize I have two other coworkers here with me from CSG Justice Center. I have both Michelle Feldman and Nina Solomon. They are going to be speaking on different topics than JR, so we'll introduce them as we go through. I am only going to take up a brief amount of your time as I did send on to you all a 66-page final report on justice reinvestment. I am happy to answer any questions. I also don't want to eat up any of this important topics time. So I will move through at a good clip, but please feel free to stop me at any time for questions. All right. I hope you all can see my screen. I'll go to full screen here. Let me know if that did not work. Awesome. All right, so I will go ahead and get started today. So just briefly, for those in the room that may be new or unfamiliar with the CSG Justice Center, we are a division of the Council of State Governments. We're a national nonprofit, nonpartisan organization that combines the power of membership with state officials in all three branches of government, policy and research expertise to develop strategies that increase public safety and strengthen the communities. Our goal there is to bring people together, and that definitely took place in Wyoming. We want to drive the criminal justice field forward with original research. Again, as you will see, or as you saw in our report to the state, that definitely took place in Wyoming. We want to build momentum for policy change. The state is moving forward at such a great clip and provide some expert assistance in doing so. Our goals, of course, with justice reinvestment and with CSG Justice Center is to break the cycle of incarceration, to stop that revolving door into our system, to advance health, opportunity, and equity, and to do so through the use of data. So what is justice reinvestment? For many on the committee, this might be old hat to you all, so I apologize and bear with me here on this slide. For some of the newer members of the committee, I want to make sure that there's a good, firm understanding of it. It is a data-driven approach to improve public safety, reduce corrections and related criminal justice spending, and to reinvest those savings in strategies to reduce crime, to reduce recidivism, and to strengthen communities. JR, the Justice Reinvestment Initiative, is funded principally through the U.S. Department of Justice's Bureau of Justice Assistance, with additional funding from Pew Charitable Trusts. Technical assistance for Wyoming was provided by the CSG Justice Center. Other states across the country can also receive it from Community Resources for Justice, Crime and Justice Institute, otherwise known as CJI. JR is a tailored initiative to the specific needs of a state. So states across the country have used JR assistance for tackling state and local public safety and health challenges, to scale up recidivism reduction efforts, to enhance data collection, and to manage costs associated with state prisons. Really, in Wyoming, the state took part in almost all four of these, if not all four of these in extent. So the state really embraced the JR process and took advantage of having some expert assistance in the state and some of that additional funding. So what did that produce in Wyoming? A system-wide analysis.
Mr. Chairman, sorry. Mr. Chairman, just briefly, could we work on fixing the slides so everyone can see them in the audience?
Oh, our slides aren't scrolling.
Oh, I apologize.
And hey, Stephanie, while you're getting that running, just so you know, so you don't feel like you have to push through something that we may already know, this committee, other than Co-Chairman Nethercott, I have one individual from the House side that was on the tail end of justice reinvestment when we started that, other than myself, and I went away on a sabbatical, so I missed most of the good work. So the overwhelming majority of this committee was not serving on judiciary when we did all of this justice reinvestment work, just so you know, as you tailor your thoughts on that.
Great. And Mr. Chairman, thank you so much for that additional context. I do want to mention as well that we were, as part of the report, I did strive to include some of that additional context for the committee, so that there was some additional historical context that isn't present today, but is present in the report. I'm going to go ahead and see if.
I'm
Co-Chairman
gonna
Nethercott.
just interject here, Mr. Co-Chairman, thank you. So there's a packet that should have been provided to you. It's called What is Justice Reinvestment? Looks like this on the front. I think it's available over there on the table as well. And if you flip the page to like pages 2 and 3, there's a history of the legislation that we passed in response to the work that CSG provided to us with justice reinvestment. And I think that that can be a very helpful overview. And as you look through the packet, you can see additional legislation that was passed associated with the work from justice reinvestment. So this is the greatest tool to understand, really in a very summation, what was done with the data that we received.
Thank you, Co-Chairman Nethercott. And committee, I believe that was in your additional handouts material. You had a stack when you came in, so it may not have already been in your binder or your materials that you brought with you. Go ahead, Stephanie.
Thank you, Mr. Chairman. Is the presentation scrolling now?
Yes, ma'am.
All right, fantastic. So as I was saying, as we fix those technical difficulties, the original JR effort in the state really led to the passage of 4 pieces of original legislation. And so by that, I mean what the state really took on in the earliest stages of JR in 2018, 2019. And that resulted in SEA 19, HEA 53, HEA 15, and SEA 50. I will not go through bullet by bullet with the committee. There is greater detail both in the report and of course online on all pieces of those legislation. And then from there, apologies, let me back up, there we go. Additionally, during the interim session of 2019, in conjunction with both the Joint Health, Labor, and Social Services Committee, as well as with the this committee, CSG Justice Center engaged in an in-depth assessment of Wyoming's behavioral health system. And from that in-depth assessment, we put forth a few more policy recommendations, and the state actually passed HEA 62 in March 2020. So this latest round of technical assistance that was provided by CSG Justice Center was really around HEA 16 and getting that set up in the state, implemented, and some sustainability practices put into place. That bill in particular called for improving the quality of and accuracy of substance use assessments, creating a behavioral health services enhancement program for community providers, which I know the state has also continued to have conversations around, adopting standardized evidence-based treatment practices and guidelines, and creating a competitive and outcomes-based funding stream for behavioral health providers. During the implementation phase of JR, CSG Justice Center provided technical assistance on 4 key areas in the state. fostering collaboration across branches, agencies, state and local leaders. That definitely took place across the state throughout our time, both in the initial phases of JR when we were doing our analyses and through the implementation phase. We provided expert guidance both on the use of risk and need assessments across substance use, generalized risk assessment, as well as evidence-based practices across multiple points in the system. So not just out in the community in the behavioral health world, but also within the correctional institutions within the state of how to help prepare folks to transition out into the community. Supervision strategies and information sharing, helped identify key metrics for the state to track and to keep tabs on, to collect data around. And we provided grant oversight for $220,000 in funding that is meant to help remove barriers to implementation and to improve Wyoming's ability to monitor progress. So all of this looked like 26 meetings and presentations with the legislature, the governor's office, different stakeholders in the state, 265 phone calls and video calls. And for many of those folks that I'm sure are listening into this session today, many of them were with you, and we appreciate that. We made 19 trips to Wyoming prior to the start of COVID-19, and that resulted in nearly over 1,200 interactions with individual stakeholders. So we definitely got to know the state really well and the wonderful people that are doing the work in the state, that crucial implementation work. As part of the phase 2 technical assistance, Wyoming received, like I said, $220,000 from BJA for various things. So as you can see here, there's a breakdown of what those funds went to. It went to everything from training for DOC staff and field services staff, to support new quality assessment unit and trainings and implementation for both DOC, Department of Health, and community providers. Training for mental health providers, prison substance use professionals and clinicians on assessing treatment needs, acquisition and implementation of online behavioral health assessments so that you would have a statewide system in place, and technological purchases associated with online assessments for video hearings for the Wyoming Parole Board. So that money was stretched as far as it could go to help the state and provide them with what they needed to really do the implementation work of justice reinvestment. The state did some upfront reinvestment for 2 of the 5 pieces of legislation passed under JR. I want to make note, highlighting that it was 2 of the 5 is not a ding in any way. 2 of the 5 necessitated upfront investment. And so the state really pulled together and got those dollars for the Department of Corrections to ensure that justice reinvestment initiatives could actually move forward in the state. So it's a great job there. You can see that breakdown of where those funds went, mainly to HEA 53, which was the incentives and sanctions restructuring and putting forward the money for those new sanctions that were put in place. And of course, HEA 62, which put forth general fund dollars to fund positions within DOC for that quality improvement unit. Before moving even more forward with kind of some of the effort, what we saw when we kind of left the state and looked back at the data that we'd collected over the last couple of years. One thing that I really want to hone in on for the committee is that it will take years to fully realize the impact of justice reinvestment in the state on the planning, the implementation, and the sustainability efforts. Implementation is an ongoing process, and Wyoming faced unique circumstances over the last year, both with struggling against a global pandemic, but also incredible financial burden, budget cuts and things of the sort. And all of that is going to obviously impact kind of those implementation efforts. We also want to make sure that we recognize that COVID-19 really impacted court processing, a reduction in jail sanctions, changes to supervision practices, and a change in the delivery of behavioral health treatment. So we highly encourage the state to keep that under consideration when looking at the results of JR here in the very beginning. It will take, we're approximating at least 2 additional years to really see the outcome of the justice reinvestment policies that were put into place. That being said, overall, trends in Wyoming have remained in line or shown slight improvements from January 2019, so prior to COVID-19. The trends, of course, were impacted by the bills and other factors, but your prison population has decreased, your supervision population has decreased. New court commitments constituted 54% of all prison admissions, which means that you're also seeing a reduction in revocations, especially among parole, as you can see, and probation revocations fell as well. Again, the state was operating slightly differently due to COVID-19, but these are all great trends to see the state moving in. Some key takeaways, and this was pulled directly from the report that was sent to you all. So there's definitely some more in-depth analyses that you can find in that report. But for some key takeaways, the state has implemented several substantial reforms in the last 2 years. It's made great progress to stand up those reforms. The initial trend data is promising, but the state will really need to continue efforts to reduce revocations and fully support JR policies and implementation and sustainability so that the trends don't reverse course after the pandemic. COVID-19 impacted everything. But on a highlight here, WDOC, the Department of Health, really created an unprecedented collaborative relationship that is ongoing. It extended beyond the requirements of HEA 62, sitting in the room with those 2 agencies and seeing them brainstorm and strategize and find solutions to problems that have been plaguing communication and other things in the system was honestly gave me goosebumps at times. The other big takeaway, budget cuts, of course, to justice reinvestment appropriations. The agency as a whole, DOC as a whole, Department of Health does, of course, it'll jeopardize the long-term success of justice reinvestment policy changes. I'll pause there before I get into any recommendations if there is any comments or questions from the committee.
Committee? Representative Zwanitzer.
Thanks, Mr. Chairman. And maybe this will be part of the recommendations, but is there anything specific in JR that addresses juveniles or that, helped at that time of implementation? Did Wyoming work at all on the juvenile side of these issues? Or is there any direct funding? I'm just trying to tie it into our topic this morning a little bit better as we move forward.
Definitely. Chairman Olson, Representative Swanitzer, thank you so much for the question. Great question, especially for the topic being considered today. Justice reinvestment is, because it is funded through the Bureau of Justice Assistance, it is focused mainly on the adult system. But Nina Solomon, who is with us today and a CSG Justice Center colleague, is going to speak towards CSG's ability to help the state with juvenile justice initiatives. So this was simply kind of a wrap up. Chairman Olson, Chairman Nethercott were kind enough to let us come in and interrupt your session a little bit here today with just a good overview of what's been going on in the state. So hopefully we can help the state and provide some technical assistance around juvenile justice. And my coworker Nina will definitely be able to speak to that.
Stephanie, I'm curious if you have a little more information when I'm going through what could be some bullet points showing that the legislation that we enacted had success. But you noted that, of course, during the COVID-19 pandemic, everything's different. So I'm curious, for example, if we look at like probation revocations fell 25% during 2020 compared to 2019. Do we have data that tells us how many revocations were reported during 2020 versus 2019? So what I'm getting at with that is it just simply that so if the number of revocations were somewhat similar, but the reported or probation violations, excuse me. So probation violations, if we have the data on that, because if those were somewhat similar between 20 and 19, but the revocations fell 25%, then that would indicate to me that maybe something legislatively that we did or that the courts or DOC is doing may show a change in policy versus if we just had less probation violations in 2020 than we had in 2019. I'm not sure that necessarily means that it changed because of a policy decision, just that less people violated probation. Do we have that data to back that up to give us a better idea?
Chairman Olson, great question. We do have some data on that, actually. So a couple of different things. We definitely saw an intake, or an increase, I should say, in the use of the incentives and sanction structure among field services. Additionally, the legislature in 2019 passed guidelines for the use of consideration of 8 factors in when revoking probationers for the judiciary. And we saw that revocations fell after that was actually implemented. And so we do have some evidence there that policy did result in change in the state. For exact numbers, some of that is in the report. I will also make sure, go back and visit that report and see if there's anything supplemental that I can add to help answer that question.
Okay, maybe I'll just take a deeper dive into the report because I'm curious about prison population decreasing the same, but I can always talk to Director Shannon about that when it comes up. So
Definitely.
All right, thank you. Please proceed.
Thank you, Chairman Olson. All right. So our first recommendation here is due to the fact that HEA 62 was actually just passed just last year. So we really wanted to emphasize that the state continue the work to meet the requirements of HEA 62. So the Department of Corrections and Department of Health are continuing to meet and to have an active work group that is working through the implementation phases of HEA 62. We unfortunately got a little behind with starting implementation of HEA 62 due to some changes with funders and things like that, that details we don't have to get into right now. So they are continuing the implementation work as we speak. So ensuring that collaborative process is able to continue, that's meeting provider needs, service availability, quality improvement processes, and data measures. That they're able to monitor and pilot the full implementation of the structured decision-making tool that was created in order to help folks monitor the use of substance use assessments as required under HEA 62. To monitor the implementation of the in-reach process that DOC and Department of Health, DOC contracted providers and DOH contracted providers are engaging in, which they are working hard on right now. Develop ongoing collaborative trainings between Department of Health, Department of Corrections, and providers to continue that conversation to make sure that there is consistency across the state, that all providers are using the same language, that they are approaching folks coming out of the, or coming back into the community in the same ways, and to create a single identifier to use across all agency data systems to ensure individuals are tracked through the system so that there's not duplication or repetition in the system, and so that folks can get services as quickly and as efficiently as possible. Next, the state should invest in improving data systems and data collection. Continuing monitoring the implementation data trends among all 5 justice reinvestment bills, explore the following questions, which I'm not going to read to you all, but when more data becomes available, it would be great to revisit, especially post-COVID-19 pandemic. Assist counties and jails in strengthening data collection and reporting so that state leaders can understand the local impact of policies. That was definitely one of the hurdles that we encountered during the initial phases of our analyses in the state, was just that getting data from the local jurisdictions, whether that be because their data systems were compatible with the larger state ones, maybe it was just that their data systems were so outdated that it was hard for us to kind of connect with them. And the courts should examine ways to improve data collection on their side of things to determine how judicial decision-making is impacting the criminal justice system, specifically how judges are incorporating JR legislation into sentencing decisions regarding probation modifications. So Chairman Olson, one of your questions that you actually asked there, how do the courts improve their data collection efforts to better track how they are adhering to policy? And to continue to engage and work with stakeholders across the state that are contracted to provide services to those at the intersection of criminal justice and behavioral health. The availability of and access to behavioral health services in different regions of the state has been impacted by COVID-19 and budget cuts. And that impact should be closely monitored for negative impacts to criminal justice system outcomes and to populations. Consider outcomes-based service contracting, including data collection and reporting, regular performance and outcome reviews between the state contracting agency and the provider, on and off-site visit monitoring, outcomes validation, incentive payment approvals. So it's something that goes a little bit beyond one metric, such as recidivism, taking a look at how the program is actually adhering to evidence-based practices, as well as some of those things that the state requires of them. Monitor justice reinvestment data and utilize data to guide internal agency training needs and stakeholder engagement strategies in all JR policies, including the use of core correctional practices, PRISM, which is the incentives and sanction structure, and risk need assessments. And finally, a big ask here, the state should ensure the enormous effort that has been put into implementing justice reinvestment policies is sustained long-term, so that the state can finish implementation, measure the impacts, and sustain change. Ensure staffing levels are appropriate to allow for the use of evidence-based practices, both within DOC and Department of Health. Restoring funding to the original appropriation for HE 62 to support DOC and the Department of Health in their efforts to improve behavioral health systems. Restoring funding to the original appropriation for HEA 53 to hold people accountable with swift, certain, and proportional sanctions. And DOC and WDH should work with judges to educate them on using research-driven strategies to reduce recidivism, to assist them in working towards utilizing behavioral health resources. I do know anecdotally that DOC is in the process of working with judges across the state and educating them on the JR bills that have passed, different policies that have changed as a result, different initiatives that are taking place. So I know they were working hard on that. And that is the end of my portion of the presentation. So I will pause again for any questions.
Committee, any questions? All right, let's keep it rolling.
Great. Well, I will throw it over, theoretically, throw it over to my coworker, Nina Solomon, who will take over and describe to you the juvenile justice possibilities that CSG Justice Center can assist with.
Great, thank you, Stephanie, and good morning, everyone. Thank you to the co-chairman Olson and co-chairman Nethergott and members of the committee, again, for inviting me and Stephanie and Michelle here this morning to share our work with you all. As Stephanie mentioned, I'm going to share more about our juvenile justice program here at the CSG Justice Center. As Stephanie talked through her justice reinvestment project in Wyoming, our process for how we partner with states and jurisdictions around the country is very similar to the JR process. So I think my presentation will build upon the work that Stephanie and her team did in partnership with you all in Wyoming. So I'm going to share my screen as well and talk through our work here at the Justice Center on juvenile justice. And I'm going to start by talking more about the research and why we feel at the Justice Center that it's important for states and jurisdictions who are looking to reform their juvenile justice system to take a comprehensive look at their entire juvenile justice system and not just at one piece of the system or one piece of the continuum. So I'm going to also provide some background research around juvenile justice best practices as I go through my presentation. So let me share my screen. There we go. So our juvenile justice program at the Justice Center is focused on two main goals. One, to strengthen or improve public safety and communities. And the second is reducing recidivism and improving outcomes for young people that come into contact with the juvenile justice system. So while there are some organizations that focus on a part of the juvenile justice system, whether looking at prevention or looking at incarceration at the deepest end, our juvenile justice program really focuses on the entire continuum from point of referral all the way through reentry if young people are incarcerated at the deepest end of the system. And we do that in a couple different ways. We produce original research at the Justice Center on discrete juvenile justice issues and topics and try to push the field forward to look at that research and use that research to inform their policies. And then we also provide direct technical assistance to states and jurisdictions around the country to help them align their policies and practices and their resource allocation decisions with what we know works from the research to get better outcomes for young people. And so I'm going to start by talking about a groundbreaking study that we conducted in Texas, which really serves as the background or the foundation for a lot of the work that we do around the country with states and jurisdictions. And I feel also has implications for the work that you all are trying to do in Wyoming in terms of reforming the juvenile justice system. And on this slide, you can just see the array of states and counties that we've partnered with over the last several years to help.
Mr. Chairman.
Yeah, I think, Ms. Solomon, we have the same issue where our slides aren't transitioning as you present.
Okay, let me try that again. Is that working?
Yes.
Okay, great. Good thing is I was only on my second slide, so yeah, hopefully it didn't interrupt too much. This slide really just shows the different states and jurisdictions that we've worked with over the last several years to help them facilitate juvenile justice improvement. So I'm going to start again by talking about a groundbreaking study that we did in Texas, which really serves, as I mentioned, as the background for a lot of the work that we do with states and jurisdictions. And the reason that we chose Texas, we do have a research division that is based in Texas, but Texas also has a very robust juvenile justice data system. So we're able to do a lot of research using that data. And the reason that we decided to embark on this study was that we have seen states around the country really decline in terms of their incarceration rates pretty significantly over the last 10 years. Nationally, we've seen about a 60% decline. I would venture to guess after the COVID-19 pandemic in the last year, we've seen an even greater decline in terms of the young people that are placed at the deepest end of the system. So that right now in most states around the country, young people are primarily supervised in the community under probation supervision or through diversion. And policymakers were asking, as we've made that shift from incarceration back to the community, what kind of outcomes are we getting for young people? And are our changed policies actually having an impact in terms of resource allocation decisions and outcomes for the system in general? And so we did a Texas case study because in Texas, over the last several years, they've implemented a number of or adopted a number of policy changes through their legislature. Texas has a system that is somewhat similar to Wyoming in terms of a decentralized system where the state runs corrections, but each county runs their own probation department, so supervising young people in the community. And in the last several years, Texas closed down one of their state facilities. They reinvested those dollars back into the community to keep kids closer to home, to supervise them either in smaller, more regional facilities or under probation supervision. They also changed some laws in terms of who can be sent to state incarceration, so limiting young people with misdemeanors not being able to be sent to state incarceration. So they've changed a number of policies to help keep kids closer to home and under community supervision. And so we wanted to see the impact of those policies in terms of recidivism and outcomes. And so we were able to do that by looking at two cohorts of young people that had very similar profiles. So those young people that were eligible to be incarcerated in terms of their criminal history, risk levels, and so forth. And we wanted to see what outcomes kids had that were incarcerated, as well as those kids that were eligible to be incarcerated, but were kept closer to home in their communities. And what we found was that overall, kids that were supervised in the community had better outcomes. It was a better public safety strategy than incarcerating kids in these large state-run secure facilities. We saw a 1-year probability of rearrest of about 34% for young people supervised in the community versus 41% for those young people that were released from state-run secure facilities. And again, these are very similar profiles of young people. We found that young people that were released from state-run secure facilities were 21% more likely to be rearrested than young people that were supervised in the community. And as I mentioned, during this time when they closed down their state facility and made these policy changes, Texas invested heavily in supervision and services in the community. You can see on this slide the change in terms of spending from 2005 to 2012 in terms of money that was going to the community for supervision and services. And so again, Texas wanted to see what they were getting for this money. And this is where some of the bad news in terms of in our Texas case study came about, was that resources were comparable, or rearrest rates, were comparable despite the investment of resources back into the community. So you can see on the left-hand side, the 1-year probability of rearrest for youth prior to all of these reforms, and then the 1-year probability of rearrest post-reforms and post-investment in the community. And you can see here that rearrest rates were very similar pre and post reforms. You can still see that being placed in the community in terms of community supervision or a less secure placement in a county facility had better probability of rearrest than being in a state incarcerated facility. However, when you look at the last row, you can see that for young people that were in the community, their probability of rearrest was the same regardless of what type of intervention they received. So kids that received no intervention at all had a very similar rearrest rate after the reforms as to those youth that received a whole host of different types of programs and services, whether they were treatment oriented or surveillance oriented. So big takeaway was that young people in the community do better in terms of recidivism than young people in these large state-run facilities. However, the type of treatment, the type of services, matching young people appropriately, as we'll get to, really made a difference in terms of their probability of rearrest. We also developed a composite risk score in doing this case study to see if youth were being matched appropriately to the type and level of supervision. The composite risk score helped us to indicate what youth should have gotten based on their risk level, and then what they actually got in terms of supervision. And so you can see here that based on that composite risk score, of youth where we would have expected diversion based on their risk level and other factors, only 21% of youth were actually diverted. And on the right-hand side with probation, of youth where we would have expected them to receive probation based on their risk level and other factors, only 43% of youth were actually placed on probation and 57% were not. So you can see here that Texas was not doing a good job of matching young people appropriately to the type of supervision based on their risk level. And that could have contributed to those poor outcomes in terms of recidivism. Additionally, we saw that youth were detained at far higher rates than was warranted or expected, again, based on this composite risk score. So out of the cases where detention was expected or not expected, 91% of youth were not expected to be detained based on their composite risk score. And of that percentage, 57% were not detained, and 43% of youth where detention was not expected based on their risk level or threat to public safety. 43% of those youth were still being detained. So again, not doing a good job of matching young people with the most appropriate type of supervision. We also saw that youth were not being matched appropriately to services. This is something we see in Texas, but in other states and jurisdictions around the country that, for example, with substance use treatment, we see a lot of states and jurisdictions providing substance use treatment to a lot of kids that might not even have a substance use need. And that is not only a poor use of resources, but it also doesn't get the best outcomes. So you can see here on this chart, all of the various counties in Texas, the number of young people that were actually identified as having a substance use need when they were referred versus on the right, the percentage of those youth that were actually in a substance use program. So again, poor matching of kids to services based on their identified needs. We also saw that high-risk youth were spending less time in programs and services. And what we know from the research is that with low-risk kids, often if you do nothing at all or provide very minimal intervention, they're going to grow out of their adolescent behavior, and that you get the biggest bang for your buck when you spend your time and resources on the highest risk youth. And you can see here again by county that low-risk youth were spending more time in programs than higher risk youth. The other thing we saw when we dive deeper into the data to figure out why recidivism rates were comparable regardless of the intervention or no intervention at all was that the registry of programs available in each county for young people in the community lack clear standards on what constituted evidence-based or research-based. So we know from the research what types of programs and services actually work to improve outcomes for young people and reduce recidivism, and what types of programs and services, those are more punitive or focused on surveillance, boot camp type programs, for example, actually result in poorer outcomes and are not based on research. And so young people were being placed in programming that might not have been evidence or research based. Additionally, while data was being collected, they were not using the data to track fidelity of implementation in terms of these programs and services, or to look at youth outcomes and hold providers directly accountable for recidivism and other outcomes of young people that were participating in their programs. And so we figured that it was, or provided recommendations to Texas that it was essential to really define performance measures and collect that data in terms of service participation and service outcomes, disaggregate that data and use that data to improve services, improve matching of young people to services, and really to invest their dollars in what we know actually works to improve recidivism or reduce recidivism and improve outcomes for young people. So this study, as I mentioned, had a lot of implications for the work that we do in states and jurisdictions around the country and for Wyoming as the state is looking to reform its juvenile justice system. So the first is that we found out through our study that focusing on reducing the use of incarceration is successful and is needed, that keeping young people in the community whenever possible is the most cost-effective strategy and the best strategy to improve and strengthen public safety. We also know that despite using decision-making tools, so in Texas, they do use a risk assessment instrument to measure risk level as well as needs of young people. Young people are often not being matched to the most appropriate level and type of supervision and services. And we see that even more so for young people of color. We also see most jurisdictions and states struggling to ensure that youth are actually receiving services that are targeted towards their individualized needs, that is based on research, and that is effective. and that what doesn't get measured and acted upon doesn't get done. So again, ensuring that data is not only being collected and tracked, but that it's being used to make decisions in terms of policies, practices, and the allocation of resources. The other piece of research that I want to quickly mention before I go into more description of how we partner with states and jurisdictions is that we published a report called Core Principles about 5 years ago, which synthesizes the research around what actually works to reduce recidivism and improve outcomes. And these 4 core principles are what we use to drive our assessment of state and local juvenile justice systems. And those 4 core principles, and I can share a link if I haven't already to this document on our website. The first is making sure that supervision, services, and resource allocation decisions are based on the use of validated risk and needs assessment. So we're actually looking at use risk levels, we're looking at their identified needs to make decisions about their supervision type, their supervision level, and what services they should receive, whether they are in the community or in a facility. The second is to actually adopt and implement programs that we know work, that have been demonstrated by research to reduce recidivism and improve outcomes, and to use data to look at results and make improvements to the system based on that data. The third is to employ a coordinated approach across service systems. So what we know is that when young people are involved in the juvenile justice system, they are also involved in other youth serving systems. There's typically an overlap with child welfare, for example. Young people that come into contact with the justice system, a majority have behavioral health issues, many have struggled educationally. And so it's incumbent upon all of these systems to work together to address youth needs. It can't be just the juvenile justice system that works alone to support young people and try and get better outcomes. And the last piece, and I think I heard this being mentioned by Brian early in his comments, was that youth are not mini adults. They have distinct developmental needs, and that system policies, programs, and supervision practices must reflect the distinct developmental needs of adolescents, and making sure that the services and supervision are really tailored for kids and for what we know about adolescent brain development, and a lot of new research that has come about in the last several years. So that kind of ends the research portion. I'm happy to share more information. I know I went over the Texas study fairly quickly. That is also the findings from that study has been published in 2 reports that's available on our website, Closer to Home, I'm sorry. And we can provide those if we haven't already. But I wanted to move now to talk more about how we at the Justice Center use all of that information to partner with states and jurisdictions on the ground to help them improve outcomes for young people through juvenile justice system reform work. So we do this through our Improving Outcomes for Youth initiative, where we help states and jurisdictions align their policies, practices, and resource allocation decisions with the research. That is the primary goal. We are a nonpartisan organization, as Stephanie mentioned. We have worked with states around the country that are very diverse and where their juvenile justice systems look very differently. And we help policymakers and state and local leaders try and answer 3 key questions about their juvenile justice systems. The first is, what are their recidivism rates and what do outcomes look like for youth that are under system supervision? What data is being collected? How is that data being used to track, analyze, and improve outcomes? Are youth being matched with the most appropriate level, type, length of supervision? Is supervision tailored and addressing youth risk and needs based on the use of actual validated risk assessments? And is the state or jurisdiction using resources most efficiently to provide services for youth that are highest risk for reoffending? And are the services that young people received actually demonstrating effectiveness, and are resources being allocated appropriately to those services? And we do that through 4 key phases of work. And this looks very similar, as I mentioned, to the justice reinvestment process. The first is the formation of a statewide task force that oversees and guides the initiative. We develop a partnership across branches of government with the legislature, with juvenile justice agencies, with judicial officials, and other key stakeholders to take part in a statewide task force over a 9 to 12 month process that really structures the initiative, identifies priorities for juvenile justice system reform, and is ultimately the body that approves or reaches consensus on how to move forward in terms of adopting policy change. At the Justice Center, how we support the task force is we analyze case level juvenile justice data, we review policies and practices, and we conduct a qualitative assessment. So we would get access to case level juvenile justice data. And again, I know I heard Brian talk through how data is being collected in Wyoming, and every state and jurisdiction that we've worked with, their data looks slightly different. Some have better data, some have less data available, but we analyze the case level data that is available across the juvenile justice system from point of referral all the way through reentry, looking at every decision point, looking at equity issues, looking at expenditures, and we couple that with focus groups and interviews with all the relevant stakeholders involved in the juvenile justice system, as well as youth and families that are most impacted by the system. And we review agency policies, procedures, as well as statute. And we present all of that information back to the statewide task force in a series of findings presentations that are meant to help the task force identify gaps and challenges and identify priorities for improvement. We then work with the task force to develop recommendations to adopt policy change, whether that's legislation, agency policies, court rules, appropriations changes, based on the assessment findings to help the state reduce recidivism and improve outcomes for young people. And then we work with the state to develop and adopt legislative, appropriations, administrative policy changes for improvement. Like the JR process, we also provide states with technical assistance after the fact, after policy change is adopted, to ensure that adopted policies are implemented with fidelity. As Stephanie probably understands better than anyone, in working with states on phase 2 of JR, that passing legislation can often be the easiest thing to do, but implementation is really where the rubber hits the road. And so we are poised to provide states with technical assistance on implementation as well. And this just shows the various types of implementation support that we can provide and have provided to states and jurisdictions around the country. Our process is collaborative and data-driven, and it's focused on concrete policy, practice, and funding changes. So very similar to JR, we partner with all leaders across the state through a collaborative process. We try and build upon past and current reform efforts. We know that we don't enter a state in a vacuum, but that the state has already been thinking about juvenile justice issues prior to us partnering with them. We are objective. We provide a comprehensive system-wide view of the system, looking at outcomes, equity, and doing case level data analysis. We apply the research on what works to help identify opportunities for systemic improvement. And again, we provide implementation support to look at the long-term impact of change. When we partner with the state or jurisdictions, there's a couple of things that we look for as well in terms of the states that we decide to partner with. As I mentioned, the formation of a task force, typically co-chaired by state legislators, but we've had them being chaired by state agency leaders, judicial officials as well. The transparent and timely sharing of juvenile justice system data and other data that's relevant to youth in the juvenile justice system. So again, partnering with state agencies, courts to get access to case level data is very important to this process. Having a commitment across all branches of government, across state and local agencies, particular in a system like Wyoming, where a lot of the system is overseen at the local level. As well as commitment from stakeholder groups in the community to the potential for policy change resulting from this process. And the last piece is collaboration across other youth serving systems that work with young people and having young people, families, and communities be a part of the process. And as I mentioned early, we've done this in a number of states around the country. These are just 3 states where we have passed comprehensive juvenile justice reform. So in 2017, we worked with Nevada and then Governor Sandoval to pass comprehensive juvenile justice reform. The left-hand corner in Colorado, we passed comprehensive legislation in 2019. And then most recently, this past legislative session, we worked with North Dakota as well to pass juvenile justice legislation. And I'm happy to provide additional details in terms of what components or provisions were included in those bills, as well as share the legislation that was ultimately passed and signed in those states. And here are just some examples of best practices. I know when we talked to Brian and others that it was important for us to share examples of what other states and counties were doing around the country to help improve their juvenile justice systems as examples for Wyoming. And in these 2 slides that I'm going to share, I'm not going to read each bullet, but they provide some examples in terms of discrete policy changes that states have adopted in recent years. Some that have focused on expanding diversion opportunities for low-risk youth to avoid juvenile justice system involvement, limiting the use of detention just to public safety, and using detention screening tools to inform admission into secure detention, using risk assessment tools to inform dispositional decisions, to guide term lengths on supervision, using graduated responses and incentives matrices to address or respond to probation violations. A lot of states have been moving to require that all funding that goes to community-based services only be used for those that are research-based or evidence-based. Some states have developed funding models to incentivize communities to decrease their reliance on incarceration and to provide more community-based alternatives. And a lot of states are developing performance measures for service providers to hold them accountable and make sure that they're getting better outcomes for young people that are using their services. And then this slide provides some examples of how states that are similar to Wyoming that might have a decentralized system are collecting data on juvenile justice system involvement. I can provide more information on this, obviously connect folks to folks in these different states, I'm sorry. Texas, as I mentioned, has a very robust data system. And it's a primarily county-run system through juvenile probation departments, but the state agency requires that the county-run departments provide extracts of case-level data monthly. And there are specifications for the data elements and how these counties must submit that data to the state agency. Pennsylvania also has a primarily county-run system. They utilize a statewide case management system, so everyone's on the same data system to collect and report data on dispositions and recidivism. And similarly in Iowa, they maintain a statewide juvenile justice data warehouse that has information from all of Iowa's 8 judicial districts that provides access to court data and court statistics. And we've worked with a number of states to help them develop short and long-term improvements to their data collection and data systems. We know that data infrastructure can be really expensive and resource intensive. And so there are some short-term strategies that states can use as well in terms of setting standards, shared definitions, helping jurisdictions track and use data in a more consistent fashion, rather than just trying to throw resources and overhaul a complete data infrastructure, which we know is very expensive. So I'll stop there. I know I talked for a while and shared a lot of information, but happy to answer any questions.
Well, I'm not surprised on Texas's failure, though I rarely would look to Texas as an example for justice in Wyoming. Co-Chairman Nethercott.
Thank you, Mr. Co-Chair. I would agree with that assessment that Wyoming does not look to Texas for guidance on anything related to criminal justice. But that said, there's a lot of good information to be had there. An excellent presentation and excellent data, and excited to see what can be done on this front. So thank you for that. But one just pending question, and I know we're not here to study Texas, but it is a bit curious to me as to why they are failing to apply the lessons learned from the study that CSG has assisted them with there, and what assessment, why are their assessment tools so, ineffective at placing juveniles with the right services? And how do we make sure that Wyoming can get on that sooner rather than later with appropriate assessment tools?
Ms. Solomon?
Sure. Thank you, Chairwoman, for that question. So this study that was done in Texas was a few years ago. I'm trying to remember the exact date, maybe 2017, 18, when we published that report. And so Texas had engaged in a number of reforms that yielded positive results. And they do use a validated risk assessment tool. It was just that the folks that were using the tool weren't using the results of the instrument to match young people with the most appropriate supervision and services. And it's not just in Texas. We've seen this in a number of states where they are using a validated tool, but they're not using the results of that tool, whether that's a judicial official or the supervising agency, probation, or the state agency, using that information to actually match kids with services and supervision. So it's not just adopting the tool, but how they are using that tool. And I think until they looked at the data to see that they weren't using the tool appropriately, that's when they were making the changes over the last couple of years.
Follow up. Ms. Representative Oakley.
Thank you, Mr. Chair. Thank you, Ms. Solomon, for that. But going to some of the data that I'm looking at here, one of the things I hear repeatedly is that we need to have accurate information to base decisions on in order to be effective and to implement effective programs. I'm looking at this like Harris County. That's Houston. It's about 4 million people. 3,700 kids were identified as having a substance abuse need, and they only managed to get 12 into treatment. That would either clearly be an abject failure, but I have a hard time thinking that would be accurate. I'm just saying, I think if I got a hold of people in Houston, they probably got more than 12 kids in.
Representative Oakley, that's 12%.
Oh, 12%. Thank you.
Yes.
That helps. I was like, that's ridiculous.
It's still an astonishing
abject
number.
Failure.
Yeah, it is a failure.
But so I guess my question would be, I mean, all of these numbers are extremely low. And in opposition maybe to what I heard from the chairman, I've lived in Texas, and they have a fairly sophisticated, and they have some good money, and they have sophisticated programs. So I guess, one, have you seen improvement? But two, do you believe that these numbers are accurate?
Ms. Solomon.
Yes, thank you, Mr. Chairman and Representative Oakley. So what that slide shows is the number of youth that were identified by the risk and needs assessment to have a substance use need, and then the percentage of those young people that were identified with that need that were referred to a substance use program. So there could be a lot of other kids that were referred to a substance use program, but they were not actually identified as having a substance use need. So what that slide really shows is that they're not matching the right kids with the right services, that youth with substance use needs might not be getting substance use treatment, and youth without substance use needs might be getting the substance use treatment. So that's what that slide was trying to show. But yes, I mean, I do think obviously there could be some slight inaccuracies with the data in terms of how they report information, but we were able to get direct access to their case level data. Obviously, there can always be the way people enter the data can always be slightly misrepresented, but yes, we got access directly to each county's system.
Representative Provenza.
Thank you, Mr. Co-Chairman. So my question is, in the implementation, if the recommendations are there, and it sounded like in Texas what was happening was perhaps judges or the people on the ground were not implementing those recommendations, was there effective maybe training or something to help the people on the ground understand what the statute was trying to get at and what the best practices were.
Ms. Solomon?
Yep, thank you, Mr. Chairman and Representative Provenza. So with Texas, we actually didn't provide them with assistance in terms of their statutory changes or their implementation. We really just did a research study, an evaluation of the impact of their legislative and other policy changes. And so we presented them back with this data, this impact evaluation, but we did not provide them with support. We provided them with recommendations in terms of how to better use supervision and services, better match kids appropriately, use those risk and needs assessment tools. But we did not actually provide them with implementation support. So I would have to go back and talk to my research colleagues to see if we've looked at their data in the last couple of years to see if any change has been made.
Follow up, Representative Provenza?
Thank you. And do you know if Texas uses the district court judges as the juvenile judge court as well?
Ms. Solomon?
Thank you, Mr. Chairman.
Oh, sorry. Ms. Solomon?
Yes, thank you, Mr. Chairman and Representative Provenza. I don't know their exact judicial, their judicial proceedings and how they use their various courts, but that's something that I can check with my colleagues down there.
I suspect they spend a lot more money than Wyoming does on Co-Chairman Nethercott.
Mr. Co-Chair, thank you. I do think it would be helpful to understand how they're doing now. So it seems to me the answer was as to why they're not having the results that they should be having is just a complete rejection by the decision makers concerning the validity of the tool. Right? This is what the tool says. This is the risk assessment needs of this youth. This would be an appropriate service. I'm going to reject that and do what I think is best just subjectively. It sounds like is what's occurring. And so I would like to know why, what is it that is driving that rejection and going with the subjective analysis, or if they have created more trust in the system and then are seeing the appropriate outcomes. Only because I think in this regard, there could be a similarity of outcomes here and want to make sure we understand that failure before we start on this process, because I do think one of the pieces that may be somewhat differently based on what the Texas study is that this would be legislatively driven changes as opposed to maybe what Texas experienced, which was more organic from the system itself. And despite that, there's still this rejection of outcome. So just some curious differences there that I'm worried about as we start on this venture, ensuring that any changes that are made are actually implemented.
Ms. Solomon?
Yeah, thank you, Chairman. So with Texas, I would venture to guess, because it's very similar to what we see in every state and almost every county that we work with in terms of juvenile justice reform, is that while the state might be using a validated risk assessment tool or might be using a validated detention screening tool to inform what young people are getting admitted into secure detention, there's a lot of instances where there are overrides of those tools, whether by a judge, by an intake officer, supervisor, by a chief of probation or supervisor. And a lot of that has to do with training. A lot of that has to do with requirements in statute that those states might not have. But there is a lot of opportunity to not use the results of these instruments. And so it's more than just having a tool that's validated, but it's actually how is that tool being used, what guidelines and requirements are in place around those tools, what quality assurance data are you collecting to ensure that these tools and the results of these tools are being used? A lot of states have not been doing that. And now I think one of the changes that we are seeing is that states are requiring data to be collected on the use of these tools. How many times are the tools being overridden, for what purposes? And so I think it's the front end, having the tool, but it's also the back end, the guidelines and the quality assurance and the progress monitoring around the implementation of the tools.
Ms. Solomon, I think you said earlier when you were looking at page 10, that one of the Texas failures was not, although the tools were there, they weren't necessary. We don't believe they were properly aligning them to the correct supervision or treatment, which is probably, in my mind, would be the most drastic failure. And I think of, from a legislative standpoint, you know, in Wyoming, there's really not, I don't know that there's a whole lot we could do there other than that could be additional, you know, funding, but that seems more like that's not a legislative failure. If the policy exists, it's more of how you implement it, the policy decision makers, as Co-Chairman Nethercott pointed out, or just those tasked with carrying it out. I'm curious on those levels of supervision. So I understand, you know, matching the youth to the appropriate level of supervision based on their needs and treatment needs is obviously critical, but I'm also curious if certain types of supervision are generally more successful across the board for juveniles, whether that's diversion, deferment, probation. What, you know, is there, do they all just work based on the needs of the individual, or is there something that's generally more successful?
Thank you, Mr. Chairman. That's a great question. So it's more the latter of what you said. It's really, supervision should really be based on a young person's risk of reoffending. And so we know from the research that over supervising low risk kids actually gets poor outcomes for those youth. They get more entrenched in the juvenile justice system. And so diverting those low risk youth is the best supervision option for those young people. There might be instances where a young person needs to be incarcerated in a facility, but that should be reserved for those highest risk kids. But risk level really should be the main factor that drives matching of supervision. And incarceration really should be a last resort. And we saw from Texas and in other studies that incarceration produces the worst outcomes in terms of recidivism and positive, more successful outcomes for young people.
That, Ms. Solomon, that last part was my follow-up question. And broader than Texas, do you know, nationally, I would assume that trend is similar, that incarceration yields much higher recidivism rates than a diversion or a probation. Is that consistent across the board?
Yes, that is correct. That's consistent across the board. And that's why we have seen nationally an over 60% decline in incarceration. Almost every state in the country has declined their population significantly over the last 10 years to align with that research.
Does Texas have, you said that it's more decentralized like Wyoming. One thing I don't believe that, well, one thing that Wyoming doesn't have is uniformity in a diversion program, so to speak. It's really local. It's very decentralized. Is that true for Texas, or is there something more uniform at the state level in terms of diversion?
Yep. Thank you, Mr. Chairman. Yes. So in Texas, it is somewhat similar to that, although there are statewide guidelines. Colorado is another state that we've worked with and are continuing to work with that passed legislation in 2019. They have a similar system where district attorneys are the entry point to the juvenile justice system. Every judicial district operates their own diversion system with different requirements around eligibility, what types of services, who gets diverted. And the bill that was passed there in 2019 looks to make that a little bit more consistent so that there isn't justice by geography. So one kid in one part of Colorado would get access to diversion, where in another part of Colorado, that same kid would not have access to diversion. And so legislation was created, even though diversion is operated at the local level, to create more guidelines and consistency across the state. I will say that in Colorado, there is state funding, though, that goes to each district attorney's office for the operation and provision of diversion programs. And so through that funding, they're able to create some of those consistent requirements or guidelines.
Yeah, that's the key. And it looks like Wyoming was on that path. We had a block grant that we block granted down to the locals. In Texas, is there state funding for their local diversion programs, or do they have another funding mechanism that's local?
Yes, Mr. Chairman. So I would have to go back and look at that. I know there is state funding that goes to each county probation department. I believe in Texas, diversion is run out of the probation department and not out of the district attorney's office. So I think that the funding that goes to the county probation department is used also for diversion, but I would have to go back and make sure of that.
Representative Washut.
Thank you, Mr. Chairman. When a state partners with CSG to do a study like Texas did, who pays for that? Is that grant funded? Does the state pay for it? And how do those costs shake out?
Ms. Solomon.
Thank you, Mr. Chairman and Representative Washut. Yeah, that's an excellent question. So when we partner with states like Colorado or North Dakota, right now we're in Indiana and in Michigan doing comprehensive assessments of their state juvenile justice systems. Unlike justice reinvestment on the adult side, we are not funded by the federal government to do that work. And so the funding mechanism in every state and jurisdiction looks very different depending on the funding that's available. So a lot of times the funding comes directly from the state to contract and partner with us. In some states, we have used foundation funding if philanthropy is available in that state or jurisdiction. But it's typically state funded, and we try to the best possible tailor our approach and our work based on the funding that is available, but it is different in that we don't have access to federal funds like the adult justice reinvestment process.
On a side note that's somewhat fun, Ms. Solomon, you share the same last name as the middle name of my youngest child. Spelled slightly different, though. Anything else, committee? Senator Cost.
Thank you, Mr. Chairman. I was wondering if the failure results from a lack of buy-in or a lack of understanding of how they need to follow through. I'm just wondering where that failure comes from. Is that a possibility that there's a lack of buy-in, or is it a lack of understanding how to perform the program as created?
Ms. Solomon.
Sure. Thank you, Mr. Chairman and Senator. I think it's a combination of both. I think in a lot of states and jurisdictions that we've worked in, there has to be a little bit of a culture change in a lot of the agencies in terms of how to work with young people and how it is different than the adult criminal justice system. So some of it is buy-in and philosophical change. And also some of it is just implementation. We know that implementation is hard and there isn't always the training after the fact, after these policy adoption or policy changes are being made. And so I think it's a combination of buy-in at the front end. And that's why with our process, we try and get everyone bought in from the beginning in terms of identifying the solutions to these challenges. And then I think on the back end, the training on implementation and what is good practice across stakeholder groups, judges, district attorneys, public defenders, probation staff, line staff and facilities. I think it's that as well.
Co-Chairman Nethercott.
Thank you. Thank you, Mr. Co-Chairman. Thank you. Kind of following up with Representative Washut's concern about costs. When you did criminal justice reinvestment, was it particularly difficult to get that data in Wyoming, or more costly in Wyoming than as opposed to other states?
Ms. Solomon?
Sure. Thank you, Mr. Chairman and Chairman Nethercott. You're talking about the adult criminal justice data that we accessed?
Correct.
So I would ask Stephanie about that data. I would say that everywhere that we've gone, adult criminal justice data is always more available and robust than juvenile data. Juvenile data is not collected typically to the same level and extent. And so it's always more challenging for us on the juvenile side to get access to data than the adult criminal justice system. Also, we have seen in most states that the adult data is centralized in one location oftentimes, whereas in the juvenile system, it's in multiple data systems and multiple agencies.
Follow up, Mr. Chairman.
Yes, please.
And then the Pew Charitable Trust, I know, which has taken an interest in this particular topic across the states. Do they provide, would they provide funding as well? Some funding?
Ms.
Thank you.
Solomon?
Yes, sure. Thank you, Mr. Chairman and Chairwoman Nethercott. So yes, Pew Charitable Trust has done a lot of juvenile justice work in the past, similar work as this. But to the extent or to the knowledge that I have available, they are not doing that anymore in terms of juvenile efforts. They're focused more on the adult side from now on.
Senator?
Thanks.
All right, committee? Do we have, you have one last presenter from CSG? Or we?
Yes, Mr. Chairman. Yeah, there's my colleague, Michelle. You know, I wanted to present about the juvenile program writ large, this comprehensive view. But my colleague, Michelle, is able to present information on a discrete topic that is more short-term in nature that the committee may want to consider. So
Wait, so Ms. Solomon, are you saying that you have more as well for us?
I don't. No, my colleague does. I'm sorry.
Oh, okay. I thought you said you wanted to, you already presented on the broad topic when you said you wanted to. That's what you did. Okay. We'll go ahead and take a break and we'll be back at 10:45. meeting back. There are two things of important note. One, it's getting hotter in this room, but we're told that we have the AC cranked all the way down, but that's just a reality of the building and the fact that it's really hot outside. So Oil and Gas Commission, maybe you can take a look at your building sometime. Major maintenance. And while you're at it, number two of note is the chief executive's picture is not on the wall with all the other chief executives, which I found really interesting. Maybe that comes later in time, but he might be interested to know. Oil and Gas Commission might be interested to know. Is he on this side? Oh, he's hidden behind the pillar, so I can't see him. Okay, never mind. We've got that taken care of as well. Yeah, on the note of it being really warm in here, I suppose if you were so inclined to take off your jacket,
Except for Senator French.
except for Senator French, you may do so.
It's required that I wear it.
All right. Next up on CSG.
Hi, Chairman. My name is Michelle Feldman, and I am the program director for the Economic Mobility Team at the Justice Center. It's good to be with you today. Before I get started, I just want to make sure that my slides are working.
We would appreciate that.
Is everybody, let me try, I'm going to try to move them forward. Is it transitioning?
It's transitioning, yeah.
Okay, great.
Presentation mode, but that's up to you.
All right. Well, let's stick with this for now. Thank you again. And again, my name is Michelle Feldman. I had an opportunity to work with this committee a couple of years ago when I was at the Innocence Project, and we passed a factual innocence law. So I think it was Chairwoman Nethercott and Representative Olson. It was early on, and I remember you were both involved. So it's good to be back and see some familiar faces. And just a bit of background on the Economic Mobility Team at CSG. We're fairly new and we're focused on removing structural barriers to work and to increase opportunities for people in the justice system. So right now, with states focused on rebuilding their economies, we've launched an initiative to help state legislatures improve access to licensed professions. And this initiative, it's sometimes called fair chance licensing. And even though removing barriers to licensed work is just one part of ensuring an equitable economic recovery, it can really have an outsized impact for justice impacted people. So first, licensed jobs tend to pay higher salaries, and they could be a pathway to economic mobility. Second, stable employment is a key factor to successful reentry, and that improves public safety and also spends taxpayer dollars spent on incarceration. And third, fair chance licensing helps businesses by allowing them to pick from a wider pool of specialized talent. So you might be wondering, why am I talking about fair chance licensing as part of juvenile justice? And there are a couple of reasons. First, the juvenile population in the system is getting older, and there's a growing need to connect teens and young adults with gainful employment opportunities. Second, Wyoming's law is ambiguous about the use of juvenile records in employment decisions, and that includes in licensing decisions. And many other states explicitly prohibit the use of juvenile records in employment decisions. And third, Wyoming's current law allows licensing agencies to consider crimes that are unrelated to a profession for up to 20 years after the offense. So if somebody commits a crime as a teenager, it could impact their ability to become a licensed professional well into their adulthood, even if that crime had nothing to do with the occupation they want to pursue. So we all know that employment is a key factor in successful outcomes for both juveniles and adults in the system. And in addition to offering economic stability, it promotes pro-social behavior and positive relationships. But unfortunately, the unemployment rate for formerly incarcerated people in the US is over 25%. And that stat is from before the pandemic, so it has likely only gotten worse. And even when justice impacted people are employed, they tend to get positions that pay the lowest wages and are the most unstable. And part of the reason for that high unemployment rate is stigma, but another part is due to government policies. And according to the National Inventory of Collateral Consequences, in Wyoming, there are 125 direct employment consequences if you have a criminal conviction and 153 consequences for occupational licensing if you have a record. So really a major goal of CSG's economic mobility team is to help states identify these structural barriers and remove them if they're not serving a legitimate public safety purpose. And the reason that we're specifically focusing on licensing as opposed to other employment is because licensed professions offer opportunities that address the specific needs of justice impacted people. There is a lower barrier to entry in many licensed jobs. You don't necessarily need a college degree, for example, to become a real estate agent or an electrician. Also, a significant number of jobs in Wyoming require a license. There are 97 different licensed professions in the state. And third, licensed jobs tend to offer more opportunities for career growth and entrepreneurship. And in the last couple of years, there's been a real national movement around fair chance licensing, and states across the country, including Wyoming, have passed laws to implement best practices. But we tend to see a couple of areas that can be improved. Many laws lack clarity for licensing entities and applicants about how they're going to weigh a criminal record. And second is uneven practices across different licensing agencies. Some might use best practices, but there's really no uniformity. And the result is confusing and inconsistent guidelines, and that leads to unnecessary deterrence and exclusion of people impacted by the justice system. And people are understandably hesitant to invest in education and training, only to risk being denied a license because of a record. So the goals of fair chance licensing best practices are to establish clear criteria for how to evaluate a criminal record in licensing decisions, to implement consistent practices across professional entities, and also to ensure that criminal records are evaluated on an individual basis and in light of public safety and the applicant's specific circumstances. And just a quick history of Wyoming's current law. So Wyoming has 45 different licensing entities. And in 2018, Wyoming was one of the earlier states that passed a law creating some uniformity across these boards for assessing criminal records. It was the result of an interim study by the Labor, Health, and Social Services Committee. And it happened in a year that we really saw major momentum across state legislatures. It was really one of, in this early wave of states to adopt fair chance licensing. And since then, states have continued passing laws, and we've seen best practices get stronger. And the four main things that Wyoming's current law does is it limits consideration of crimes. They have to, it says that the crime has to directly affect the practice of the profession. Second, it repealed good moral character requirements for some licensed occupations. And that term, good moral character, could be used to justify denials for almost any crime. And the third thing the law does is it states that boards may cite as public policy specific factors for consideration, including the relationship between the offense and the profession, whether licensing would offer an opportunity for the applicant to reoffend or commit similar offenses, and whether there are opportunities to appeal a denial. And then finally, it establishes a 20-year look back period for boards to consider crimes that are unrelated to the profession. So we're not talking about crimes that actually impact the profession, but boards can still look at an unrelated crime for up to 20 years after it occurred. So the 2018 law was a really good first step, and there are still a few ways that Wyoming could consider building on that law based on what states have done in the last 2 years. So first is the direct relationship requirement. Just looking at this map, you can see there's the 25 states require denials be based on, be limited to only if the criminal record directly relates to the occupation. Wyoming is in the list of partial implementation because it references a direct relationship. It encourages boards to only exclude people whose records directly relate to the profession, but it doesn't require that. And the law is, the language is a little murky. It states that boards can cite as public policy consideration of whether elements of a crime are directly related to the specific duties and responsibilities of the profession. But again, it's not limiting exclusions to crimes that are directly related to the practice of the profession. It's just encouraging it. And one recent law that has very strong language on that point is Iowa. They just passed a law in 2020. Another factor, another best practice to consider building on is the specific factor assessment. So how boards are viewing the criminal record in light of other factors about the individual and public safety. So you could see in this chart, the majority of states require boards to consider specific factors, including the nature and the seriousness of the offense, passage of time since the crime occurred, and evidence of rehabilitation. And these are all factors that help boards to contextualize a record in light of the person as a whole. And in Wyoming, again, it alludes to some of these specific factors, but it doesn't really require boards to consider them. And it's rather vague. It says that the boards may cite as public policy. And it also doesn't reference the factors, the rehabilitation or the passage of time since the offense, which are two areas that it could include. And this is just a sample of Idaho's law that passed in 2020 that really has strong kind of evaluation criteria for boards. Another consideration is explicitly barring juvenile records. About 9 states have done that in some form, but in most other states, there are other parts of their laws that already make juvenile records confidential, so they couldn't be pulled up in any employment decisions.
Ms. Feldman?
Yes.
On that note, what I don't see is a national chart in here on the look back period.
Oh yeah, we're getting to that. I saved the best for last, so.
Oh, that's probably okay. I'll be patient.
Yes, 2 more slides. So another best practice is requiring boards to specifically write out the reason for denial and reference back to those specific factors. And that's really an enforcement mechanism to ensure that the boards are doing what they're supposed to and, evaluating the person as a whole. And then here we come to the time limit considerations. So as you can see, other states that limit, there's a number of states that, have time limits on considering old crimes. And Wyoming is in the partial category because the current law states that there's a 20-year look back period for crimes that are unrelated to the profession. So that means that a crime, having nothing to do with practicing a profession can still factor into employment decisions, 20 years later. And if someone goes to prison at age 21 and they're released at age 23 and they're paroled at age 25, that conviction can still be used to deny them a license until they're 41 years old. And that again is in situations where the crime has nothing to do with the occupation. And in other states with time limits, they're far shorter, as you can see from this chart. And also they're related, the time limits are on crimes that do relate to the practice of the profession. And that's kind of a big distinction between that and Wyoming law. And again, with the time limit, research shows that recidivism, if you go 3 years crime-free, the risk of recidivism really plummets. So, the 20-year look-back period is rather long, compared to what the research supports. And also the law says that you have to have completed your sentence within, you get up to 10 years after you complete your sentence before that 20-year look back even kicks in. So that's just a further complication.
So Ms. Feldman,
Yeah.
so what's interesting there is that the Wyoming Fair Chance Licensing Act of 2018 limits the consideration to crimes affecting the practice of the profession. However, it allows for the 20-year look back period for any crime.
Right. Yes. So it's kind of contradictory in that aspect. And really, it could be tightened up. I'm not sure why, the language ended up that way, but that's a good observation. And really quickly, just two more possible best practices. So providing pre-application determinations for potential licensees. And this is like a big factor for deterrence. So allowing people before they go through all the training and education that would be required to formally apply for a license. Many states have adopted a pre-application determination process where boards can give a ruling before somebody goes through the process about whether their conviction is disqualifying. And finally, an explicit bar on denials based on good moral character. So Wyoming removed in some of the licensing requirements for some professions that word good moral character, which again is really subjective and could be used to justify denying a license based on any crime. But this term is still used in some licensed professions in Wyoming. So water well driller, for example, there's a requirement to be of good moral character. And one model to look at again is that Idaho law that it just bars any kind of use of that big terminology, moral turpitude or good moral character. So I've given you a lot of information, and that's all I have, and I'm happy to take any questions.
Senator Kolb.
Thank you, Chairman Olson. Generally, could you give a list possibly of the professions you're claiming and that are affected by, this issue? I've looked up a few. I'm just confused on which professions. The trades are excluded. There is no question as being a master electrician, which I am, which I just reviewed the application. So I just don't know which ones. It would be very helpful to me to find out just what we're talking about here and the impacts they may or may not have. Thank you. Thank you.
Ms. Feldman.
Thank you, Chairman, and thank you. That's a great question, and we're happy to provide more details. And in general, it's, most licenses, if you require a criminal background check, at that point, the board uses that information to decide whether or not you get a license. It factors into that decision-making process. So it really can affect all types of licenses. But we're happy to go through the specifics. It's, there's 97 different licensed professions in the state, and many of them have those good moral character requirements or, other kind of vague requirements that can lead to excluding people unnecessarily from getting a license.
Ms. Feldman, you can. Yeah, you can proceed. Unless you have a follow-up, Senator Kolb. Okay, so it sounds like maybe you can get us some specific on, you said there were how many professions? 97?
Thank you, Chairman. Yes, there are 97 different licensed professions in the state of Wyoming, and it ranges from everything from, real estate agents to contractors to electricians, plumbers, to teachers. So it covers a really wide range of fields.
Feels like we could get maybe even like a one pager that just bullet points all those professions for us.
Yeah, real quick, they're all in Title 33.
Oh.
So there's 50 different chapters, and they cover, some of the chapters cover 5 or 6 at once, like carnival, circuses, pawnbrokers, pool rooms, and bowling alleys.
Carnival?
Circuses? Yeah, dance hall operators.
Dance hall operators.
It's a fascinating chapter that the corporation deals with, but I would say while I have the mic, your corporations committee and your labor health committee have tried over the past decade to really go through our statutes. And I know they're somewhat murky, I think was the testimony, but it really is, when we listen to different boards and commissions come before us, they wanted that kind of control, that level of, we'll call it murkiness, on saying, they want certain applicants and they want some flexibility based on what the charges may have been to be able to make a decision on a case-by-case basis. And I don't know if that's fair or not, but that was certainly the testimony from many of the boards and commissions when it came to, I think we took the word moral turpitude out of 12 statutes because we didn't know exactly what that meant or how to define it, but we did leave them murky in some ways to ensure the boards and commissions had some control over what was a felony charge or a misdemeanor that would have been under that profession.
Right. We wouldn't have any lawyers if we required good moral turpitude before licensing. I'm kidding, Senator Nethercott.
It's a
And lawyers
requirement
out
for
there.
lawyers.
It is a requirement. All right. There you have it. We have our list. Ms. Feldman?
Thank you, Chairman. And there is the Wyoming Workforce Development Board also has a great document that kind of spells out every licensed profession in the state and what the requirements are. And as to the point of, leaving the language murky, that, we want to ensure flexibility, and every profession is going to have different criminal records that, might not be acceptable and might be directly related. But just, I think some tweaks, there's a good framework in the law, and just some tweaks to the language could really help, ensure uniformity, and that boards are all consistently evaluating, specific criteria. So I think we could have the balance of the flexibility and also, ensuring uniformity.
Representative Provenza.
Thank you, Mr. Co-Chairman. Do we have any data on when states have reduced the barrier here, how many people then apply for licensing or maybe have a higher likelihood of being granted a license? Do we have data on the impact is what I'm asking. Thank you.
Ms. Feldman.
Thank you, Chairman, and thank you for that question. That's a great question. Data on this issue has been difficult because unfortunately, until states pass the laws, they are not tracking prior how many people with criminal records are applying. And also there's that deterrent effect that's really significant, that reduces the number of people with criminal records even trying. So there are states that, mandate data collection. Illinois is one of the states, but it's hard to measure the before and the after. But we know anecdotally, we'll hear from, trade schools and impacted people that, it allowed them some of these best practices. It gave them the confidence to apply, knowing that their criminal record, either beforehand, they've gotten, that pre-application determination, and they really kind of know the process and what to prepare for to explain that record.
Representative Oakley.
Thank you, Mr. Chair. So my question would be this is in relation to somebody who was convicted of a crime, correct? Like, because we do have a robust diversion program, for example, and those records are confidential. So this is in relation only to conviction of a crime. Is that accurate?
Ms. Feldman.
Thank you, Chairman, and thank you for that question. That is what the language of the statute says, that it's for. It refers to criminal records and conviction. So it's not including the diversions as far as I know.
You good, Representative Oakley? All right. Go ahead, Ms. Feldman.
Oh, that's all I have.
Oh, that's it. We're in the question and answer period. Any other questions, committee? No. I think generally I would have to know more about, I think to Senator Kolb's question is to take it to the next level, understanding which professions are affected, but I would have to understand more about what happens in Wyoming. I mean, when I look at the look back period, and maybe Representative Zwanser might have an answer on why we chose 20 years, but to me, it seems like when you do something stupid at age 20 and you're now 40 and you're applying for a job, that whatever you did when you were 20 would haunt you, would be absurd. And I think most of us could probably agree with that. I don't know what everybody did in their 20s, but I would have to know. So I would have to know more about that. Even though it exists, it doesn't mean that once the record is found that the individual is excluded from employment because of the record. So I would have to know what the rates look like in Wyoming. And I would really be curious to know what it looked like per profession. Maybe, because to Representative Zwanser's point, I think even, every profession may want their standards a little bit different, and I totally respect that and get that. So I don't know that uniformity is an answer unless across the board it's those rates of exclusion because of past acts that are 20 years old. If it's uniformly across the board, then maybe you need uniformity. But if it's one or two professions, then it just may be one or two professions in the way that they do things. So I would have to know a lot more about what that looks like in Wyoming. And do we have that data?
Thank you, Chairman. So the answer again is unfortunately the deterrence effect of having restrictions in the law, we've found that it led to, we can't really see the number of how many people are rejected because they have a criminal record, because they're not pursuing that path in the first place, because they see these restrictions, they know, they're told by a program, you have this record and you might not be able to get a license, and then they don't even move forward. But really kind of the idea of building on this existing law that creates some degree of uniformity is that it's just getting a bit more specific about how each board is considering a criminal record, and it still gives them the flexibility to determine that if somebody has a murder conviction, we're not gonna, that's not gonna be acceptable for getting a license in this profession. But at the same time, people on most of these boards aren't criminal justice experts. So without, clear guidance, it's really tough for them to assess what that criminal record means in light of who the person has become over time, and how criminal convictions might relate to the practice of the profession. So it's really designed to give boards more guidance about how to, make those judgments. But we're happy to, go through and find some, more examples of how different professions, what the restrictions are and what they've determined is, for a criminal record is not acceptable. And, the licensed well pump technician, for example, like that has that good moral character requirement still. So we're happy to kind of make a list of those and get more specifics.
Yeah, homicide might not be applicable unless you're applying for the job of executioner. But on the topic of juveniles, I think that data would be important because there are basically two statutory fixes that I can see, but I don't know that there's a problem. But with respect to juveniles, you could have an exclusion for juveniles, or B, you could adjust this look back period. Either one may positively impact juveniles getting jobs, but I guess I'm just putting it out there that I don't want to find a solution to a problem that doesn't exist. But if there is a problem, then I see both of those are paths to easy solutions. But I would just have to know more about the data to know that there's a problem there.
Thank you, Chairman.
Co-Chairman Nethercott.
Thank you, Mr. Co-Chairman. If the committee is inclined, one way to move this topic forward, if the committee desires, is to evaluate what the Health and Labor Committee did in 2018, which was a robust review of this particular issue. I'm not a member of Health and Labor, but having remembered passing the legislation, I know that it was a robust review of this issue with this particular goal in mind. So a lot of the research and information may already be out there. And then I think also our importance of distinguishing between statute and those boards and commissions and licensing occupations, rules and regulations, which we don't control, but certainly could, but understanding the differences between those roles and allowing for those unique flexible options for the rules and regulations for those occupations with statutory guidance. So I would just say those two pieces is, if the committee wants to take an action, and have this be an agenda item moving forward, it can simply be is to direct LSO to continue to work with CSG and to evaluate what work's already been done without adding an entirely new heavy lift with 97 boards and licensing commissions, in understanding where some of those gaps might exist. That would be the action. Seeing you're all intrigued. It's time for another break and a reduction of this heat.
Well, and Senator Nethercott, I think it may be just thinking about juvenile justice, justice reinvestment, for example. It's hard to measure the effects of the changes because of the fact that they're so new. We went through and made a lot of these changes in 2018. Representative
I
Swanser.
think it was 8 or 9. They were all the labor health occupations only.
So we may, but it's hard to, you couldn't possibly measure accurate data only a couple of years out. So I think that's another problem that we have. But it was, if it was limited by profession,
Mr. Chairman, I believe Labor Health Committee looked at, I can't remember, some 8 or 10, and they were all the professions dealing with more health occupations, not really the gamut of what corporations we tend to do. About 30, 35 of the chapters, and labor health controls the other 10. But I mean, you probably could ask the boards and commissions and A&I to, they might actually have the data of how many people each board or commission considered who had a felony record as part of their application. I bet they would keep that data, and how many were bounced and how many were allowed. I'm not sure if they formally keep that data, but I bet you could put a request to A&I to have a call out to those boards and commissions to say, have you seen an increase, even anecdotally?
I don't want to thrust too much on you, Mr. Fuller, but that seems like that may be a pretty easy and efficient task to ask A&I rather to send that out, or at the least, we're sending an email communication to 97 boards asking for that data. And then we would at least be able to look at something and decide whether we want to proceed with anything.
Yeah, Mr. Chairman, I think that's something we could probably, with the help of, A&I and other agencies, put together.
Okay. All right. Maybe that's a good starting point. We won't have to spend too much time at least gathering that data, and then we can look at it and decide whether there's something to look at. Good.
Mr. Co-Chairman, I just went and looked at the 2018 legislation to get some ideas. There was a House Bill 11 in 18, and I can email this to the committee. That was a professional licensing time limit regarding convictions. Creating a time limit for criminal convictions that are considered for purposes of professional licensing. It did fail introduction in a budget session to a vote of 39 to 21.
So did we come back in 19 and pass that though? Because that has the 20-year look back in it. Mr. Fuller, do you know?
Mr. Chairman, I'm not sure exactly.
On the spot, do you know every bill that we ever passed?
I'm not sure how this worked, but that language that's in this House Bill 11 looks like in large part was enacted with another bill in 2018 that enacted 33-1304. Because that's subsections, the language in this 2018 House Bill 11 is subsection C in the existing 33-1304. So I think there was another bill in 2018. I'm not sure if this was amended in or what, but it did end up there.
Yeah, I think it went by one vote.
The Senate fixed it.
Sounds like the Senate did something that we just completely killed it because of what they did, but then they went back and fixed something.
We amended it in some way.
The House sent over, I'm sure the House sent over the amendment. That would make the most sense.
Mr. Chairman, it was Senate File 42. And I haven't pulled up the amendments, but that's 2018 Senate File
The
42.
Senate file was successful.
Of course.
I see. All right. All right, any other action on this item, committee? All right, thank you, Ms. Feldman.
Thank you very much.
Does that cover our CSG folks? All right, we've got 30 minutes till noon. And we do have DFS. Let's go to DFS. I think that sounds about right. Also, feel free during your presentation at all. We've been blabbing a lot. So if there's anything we've said that needs corrected or any questions that have popped up that it's the right time in whatever you're presenting, feel free to interject those.
Thank you, Mr. Chairman. Mr. Chairman, Madam Co-Chairman, members of the committee, my name is Corin Schmidt. I'm the Director of the Department of Family Services. To my left is Lindsay Schilling, who is the Senior Administrator of the Social Services Division. And to my right is Senior Assistant Attorney General Jill Kachera. Always having our attorney available is helpful. So thank you to the Attorney General's office. So a little bit about Wyoming juvenile justice system. There are slides that I'll go through probably fairly quickly, considering a lot of the content has been covered, but using it as a guide to maybe give a little bit more elaboration on some of the discussion this morning. As you go through the slides, you'll see a notation to a page number. That page number actually references the document that we supplied earlier this month last month, Wyoming Department of Family Services, Wyoming Juvenile Justice System. This is a lengthier document for just reference purposes only. There's a lot of nuances to the juvenile justice system, as you're learning through the conversation today. This is kind of our version of how we see juvenile justice in Wyoming. I may call out occasionally some tables as we walk through, because there is some helpful data in there. And then last, attachment C, which is the very last page, is a list of acronyms. We really get heavy into acronyms, and I will try not to do that, but in case I do, there is a list at the very back of your document. Okay, Mr. Chairman, and we have Rachel online who is going to progress through slides. So Rachel, if you could move to the next slide, please. And we're hoping this works. There we go. Okay. Why Home Matters. So Why Home Matters is really the department's initiative to rethink not only our juvenile justice system, but also our child welfare system. It also expands into how we interact with families, engage in families. And throughout our agency, which is more than just child protective services or juvenile services, it also includes eligibility services like SNAP, which are formerly food stamps, TANF, which is formerly welfare, child care, child support. We believe that families do best at home. So as we look through the values that guide us in a lot of our policy making, our Why Home Matters is kind of our umbrella statement, and the following values really kind of guide us in how we look at policy and direction. So first, safe at home. Children and adults, including vulnerable adults, deserve an opportunity to grow up in a home or to live in a home. Opportunities for success. Our job as an agency is to look for those opportunities to assist families, whether that's children, adults, vulnerable adults, with the services that we provide and with the case management that we do. And then last, supporting the people who support the families. This work is hard. And anyone who engages in this work, our partners, our stakeholders, our staff, we believe supporting those people will then ultimately help the people we're serving. So I appreciate the opportunity to present today and to share with you what we think about juvenile justice. But there's a few things that I want to maybe correct, and not necessarily correct, but maybe explain in a different way than what we've been hearing in terms of juvenile justice in the framework of Texas or in other states. So the framework that Wyoming looks at in terms of juvenile services when it comes to court intervention is through a child welfare lens, meaning that because a lot of those children, those youth who are adjudicated delinquent in juvenile court are part of our child welfare system that we report back to the federal government. So as a result, what we are held to for protective services, for child protective services, we're also held to for our children in need of supervision and our juvenile delinquents. So that's a little bit different than a lot of juvenile justice systems. Many juvenile justice systems are tied to their adult correctional system, whereas our juvenile delinquents are really attached to our child welfare system. If you ask us about child welfare, we're going to talk about 4E. That's a funding stream that's available to us through the federal government for child welfare purposes. Youth that are adjudicated delinquent and served by us are eligible for 4E reimbursement because we case manage them like we would any other case. There are exceptions. The boys' school, the girls' school, the children placed there are not, the youth placed there are not eligible for 4E. But that gives you an example of the lens that we look at. Part of our Why Home Matters perspective really comes from a public health perspective of prevention. So thinking about the work we do in terms of primary prevention, secondary prevention, and tertiary prevention. What is up on the screen is kind of a differentiation between all of those types of efforts. So when we think about community-based services, we're thinking about that package of goods, that basket of goods that the department offers in order to help families. So that could include our eligibility programs. Our targeted home and community-based services are starting to narrow in a little bit. So in a lot of communities, the Department of Family Services is working with local communities, probably maybe their diversion programs. We offer crisis stabilization services as a way to prevent children, youth, and families from coming into juvenile court. And then once they come to juvenile court, that's tertiary. Very targeted interventions, very specific to that family, with the goal of trying to get children and youth home. We reunify across our whole system over 80% of our cases, which means that the majority of cases that come to the attention of DFS, those children, those adolescents go back to their homes. We think that's really important. I'll try to explain a little bit more as we go through the conversation. But I think we'll go ahead and start on slide 4 with the single point of entry. We're calling out the single point of entry because this is a process that can or cannot occur, or it can occur with or without DFS participation. So the single point of entry, as Mr. Fuller has described and as you've talked about today, is that prosecutorial discretion about where a case gets filed. So do we file a case in circuit court, district court, or does it come to juvenile court? In some communities, and if you look at page 4 of the larger handout, you'll see a table that describes where and when DFS is involved in single point of entry, also where there are diversion programs, and also where there are community juvenile service boards. So the single point of entry is really what I would say is the beginning of our juvenile justice system. And as I mentioned, it may or may not involve DFS. DFS is not synonymous with juvenile justice. We are a portion of the process, but we are not the whole process. So there are many youth, many kids who get cited, who come to the attention of law enforcement that DFS may never know about. And when we talk about data and we talk about data collection, I really think that's a lot of what we're discussing. So a youth, an adolescent may get cited in a court. We may or may not know about that. It really does depend on the court, but we don't communicate with the circuit court on those types of things. I think Narina Nunez is going to talk a little bit about the State Advisory Council and the ROM system, but the ROM system is the way that they use it is unique to the data that they collect. Again, going back to the larger system we see with the child welfare system, the child well-being system, we collect information through our case management system called YCAPS. And we do have a lot of juvenile services information within that system. But those are youth who have had a case opened, have been adjudicated, and then we case manage those cases. So there is a good portion of juvenile service data as it applies to youth who have been adjudicated as juvenile delinquents under juvenile court. As far as DFS is concerned, we don't have access or control any of the data collection that happens outside of our YCAP system. We report on many different types of data for various reasons, but in terms of actually holding the data, we do not hold data outside of that. So the single point of entry then, thinking about that is that really it is that door for what it is that happens with that child, that adolescent, and where it is that they then are ultimately determined, their disposition determined. What do we do with them after this? So I won't get into a lot of detail because I know that's one, I'm not an attorney. I should have said that up front. But two, it really is a function of the county and of the county attorneys or district attorneys. And I think they'd be better equipped to talk about exactly what that single point of entry means. So moving on. So secondary prevention, targeted home and community-based supports. What does DFS do in this arena? This really is the beginning of our description of DFS involvement with these children and adolescents as they relate to juvenile services. We may engage with a lot of families in terms of protective services where a child is potentially has been abused or neglected, or there's been some sort of concern of abuse and neglect. But in terms of adolescents, delinquents, and then we'll get into children in need of supervision as part of this population as well. So moving on, I want to draw your attention to the second bullet. So the supports and services that DFS provides are intensive and individualized. When a child comes into the DFS care and custody, let me see, I'm sorry. I was ahead of myself. This is really about secondary prevention. This is about trying to prevent kids from coming further into the system. As a side note, when we talk about diversion, I think it's going to be really important to decide what we're diverting from. We look at diversion as a diversion from an out-of-home placement. Again, going back to children should stay safe at home. So how are we helping the families? What are we doing to provide support so children can stay home? We want to divert out-of-home placements. Diversion, though, in other capacities may be diversion from a criminal record. It may be diversion from a court appearance. There's a whole host of definitions. So as we work through this idea about diversion programming, I think it's important to make the distinction about what we're trying to divert. Moving on. So the types of families we work with in this secondary arena are families where there's concern about safety and well-being of children. This is the children that potentially could come into care because of abuse and neglect. We can open a voluntary case with them. We don't have any jurisdiction, but if the families want to work with us, we can work with them. We may do case planning. We may do referral to services. That applies in with our juvenile delinquents, our potential juvenile delinquents and our potential chins as well. And certainly with vulnerable adults, which is adult protective services and a little more outside this conversation. So children whose behavior is really starting to come to the attention, whether it's because of a delinquent act or it's because of maybe issues at school, trying to engage through supporting a lot of county initiatives that work to prevent those children from coming further in. And you'll hopefully hear a lot about some of the county-based programs that are available that aren't necessarily state-run or state-funded. Next. All right, community crisis beds. This is kind of a little known secondary service that DFS funds. Community crisis beds are available in 14 communities. We provide 81 crisis beds, which means that we fund access to those services 24 hours a day, 7 days a week. It's a temporary service. It's a cool down service. Children cannot stay more than 30 days. But it is a place where then families who are maybe having a difficulty, a child can go there, stay for a little bit. The crisis service will intervene and hopefully help connect those families back to community-based resources. The money for this is 50% TANF, which is the block grant we receive. So there is federal funds attached to this, and I'm making this distinction for a reason. And then 50% state general fund. So we use the general fund to match the federal dollars to provide these. This is an access issue. So we fund these services regardless if they're used, meaning we want those to be available at any time. So we do not reimburse on a fee for service basis. What we do is we grant those dollars to those providers.
So I guess, Mr. Chairman, the question that basically asked is what's the utilization rate we currently have? And I mean, do we still track that? About how many youth are there at any given time, or ensuring that, we're meeting some kind of fiscal consistency? Director.
Mr. Chairman, Representative Swanitzer, we do track utilization. Utilization this past year has been very low, but it's been very low, we think, because of COVID. We have different utilization rates throughout the state. It varies greatly. The larger communities use them a little bit more often than, say, the smaller communities. But again, it's an access issue. So in some respects, we are subsidizing the service so that it's available when it's needed.
Director, are those 14 communities? Is that, I imagine those are those determined based on past need, current need? Is it so they can reach regionally, or?
Mr. Chairman, there is a map on page 25 of the larger packet if you want to take a look geographically at how these beds are distributed. There's been really no rhyme or reason to distribution. The funding for this particular service has changed. It's very much a community-based service. A while ago, there was a lot of conversation about who should have what. What we have is a set amount of money. And what we have is a way that we determine how much of that money should go to each provider. And it really is based on this idea of bed, even though the services that they provide is more than just a bed. They are also additional services. Most recently, we had there was a few years ago, a basin group home or a basin crisis shelter closed down, and that freed up dollars. We then sent that out for bid to the providers, and then they provided a documentation based on need and then made the decision about how to fund those beds. There is statute attached to this particular set of services. The statute is outdated based on now the funding model. I don't know if it needs to be changed, but it does every now and then cause us a little bit of a hiccup when it comes back to distributing those dollars. For now, I think we've established a pretty good system, and we'll keep working with that. But based on need, Mr. Chairman, not necessarily. It's mostly based on capacity and ability of the provider to provide the service.
Because those are all private companies that we contract for, so we don't own any of the facilities or have employees providing any of those services.
Correct, Mr. Chairman. Those are all contracts.
Representative Swanser?
Would I be correct in many of those cases, those contracts are to other governmental agencies, or are they to private corporations?
Mr. Chairman, Representative Swanitzer, the lion's share are to private nonprofits. And then there is in Laramie County, for example, Laramie County government has those crisis beds. Okay, moving on. So the community juvenile service boards, I think we spent quite a bit of conversation on those in terms of and I want to commend the LSO on the memo. It really was a great memo, and I appreciated the explanations because it does save a lot of kind of time to work through it. So
You actually have no idea how much that means, because when I give them direction to search something like that, it's not very direct and obvious what I want, but somehow they always manage to figure out what I'm asking for, and they just do a phenomenal job.
Reinforcing bad behavior.
Yeah, they do reinforce bad behavior. Director, on the community juvenile service boards, tell us about the block grant that's been discontinued. That's accurate, number one, that it's being discontinued as of July 1 in our new budget. And so was that a recommendation? Where did that come from? Was that a recommendation? And I'm just curious as to why, where it comes from, why we just don't need it anymore. It's just not, we don't need to block grant that money anymore. Why was there any conversation about a percentage decrease on that block grant versus completely eviscerating the block grant? Tell me what's going on there.
Okay, Mr. Chairman, thank you. Yes, so the Community Juvenile Services Board's funding was cut as a result of our step 2 budget reductions. We calculated it so that we could continue the program for 1 year to give the Community Juvenile Service Boards time to make other arrangements. Out of the 14 Community Juvenile Service Boards that exist and that were funded, we have been told that 9 of them will continue without the funding, but maybe at a reduced level. The state, and I'm saying the state, not necessarily the department, because we really were a pass-through in a lot of ways. The state did not fully fund community juvenile service boards. They provided general fund, but communities had to make up matching, whether in kind, donated, local funds to support the totality of that program. So there's some technical information. Did we want to cut community juvenile service boards? Not necessarily. Did we really want to cut a lot of our programs? No. But when it comes to this particular area of the budget, we were forced with some really hard decisions. The community juvenile service boards are 100% general fund. We couldn't leverage those for any federal fund. So then we start looking at where we do have general fund. The lion's share of general fund is in our social services service budget, meaning the budget that we use to serve children and families who have come into the custody and care of the state. It is also where we fund our adult protective services. We were looking at reductions to the social services budget, trying really hard not to make the cut twice, meaning cutting a general fund dollar and therefore having to cut a federal fund dollar as well. So the next place we could go that was general funded was adult protective services. So we made a choice. We made a policy call. We did not reduce adult protective services. Instead, we reduced this program for the reasons I just mentioned. It wasn't federally funded, leveraged. There was community support. It wasn't a statewide program, only in 14 communities. And as the governor directed the state agencies, we can't do death by 1,000 cuts. And so he encouraged us to look programmatically, and this was one place where we could make programmatic cuts. We had to reduce in other places. We reduced rates to our providers. We reduced rates to our foster families. We cut back our staff. We made substantial reductions to the boys' school and the girls' school. So it wasn't just a matter of looking at the front end. We looked at the whole continuum of care and tried to make the best decisions considering the circumstances we were in. We believe in the community juvenile service boards. That's not to say that they don't have our support. But when it comes to a general fund reduction, like we've had to go through over the past few years, starting in 2016 even, ultimately there are choices that had to be made in considering our legislative mandate, which is to serve children in custody. The children that we were diverting are not in our custody, and we really do need to take care of the ones we do federally, statutorily, and morally have an obligation to serve.
So Director, I think one thing that's important is that even though we've eliminated the block grant, you said there are 9 communities that will continue to operate, although obviously at some type of reduced function, but maybe not. I guess that depends on other funding sources, and that's something we can look at a year, 2 year out from now. So that's important, I think, for this committee to. That's what I'm hearing, is that it's not like they're going to stop tomorrow. But what are the 5 communities that that may not continue, or is it a may not continue or will not continue?
Mr. Chairman, we did not hear from them before this testimony.
Okay,
response.
So that it could go a lot of directions then.
One county, Mr. Chairman, in particular, Sweetwater County, has not made a decision. They'll be discussing it this month with their board. So I do believe it's just going to really depend on the local efforts to continue support. And as I sit here and say why home matters, Mr. Chairman, this really was a place that we had a lot of difficulty because we want to invest in the front end. And given in any other circumstance, we could have started a conversation about what does it take to look at where our funds are and moving those around, specifically looking at the boys' school and the girls' school, because they are 100% general funded. But we've reduced them to their capacity now. There just really is not enough general fund in the system.
So Director, and you said that you have to focus your funds on really those that are placed in the system, because that's really what you do. Maybe this block grant's not appropriately placed within your budget then. If it's really a direct distribution to local communities, it's just passed through, you're just a pass through, just taking general fund dollars that would otherwise be in DFS. But if everything else you do supports those placed in your program, maybe it's just that this isn't appropriate placed. Has it always been, has the juvenile community service board block grant always been in the DFS budget?
Mr. Chairman, yes.
Inception?
And Mr. Chairman, we're a logical place for it because we have the mechanisms to distribute, and we do work with children, and we are very much interested in supporting communities. So I don't think it's necessarily a question of appropriateness, but rather just it's general fund, and we had to make a tough choice.
Oh, I'm sorry, because I thought you said that you had to weigh spending money on individuals who were placed in the system versus not, which was one of the considerations on why you made the cut. So that's the reason why I made that comment. If I would love for you guys to continue to be advocates. Not trying to move it somewhere else, but just trying to make sure it's, I guess we'll have to know more. Maybe we'll know more when those other 5 communities do answer. We'll know more, and then we still won't know enough until we see how they do without that state fund. And then we'll know even more when the Craig report tells us that oil and gas is doing better and we have more money. Okay.
So moving on, and I want to be cognizant of time. Juvenile justice diversion is also, as I mentioned, a conversation that's come up here on page 11 of the slides. Again, this is just an overview of what diversion is, but what does it mean for Wyoming, I think remains to be seen how we want to define that. So moving into number 12, slide 12, tertiary. So this is where I started to go. DFS system, when kids come into our care, they all basically get the same kind of treatment. So they are, there's a petition filed in a court, and they can come in through 3 different doors. A petition can be filed because of an abuse and neglect case, or because of child in need of supervision case, or as a juvenile delinquency case. But when they come into our care, all of them have case plans. All of them have multidisciplinary teams assigned to them. And aside from some differences with chins and delinquents, really the type of service that we provide to those families is very similar. So when we talk about things like incarceration rates, and I think I've heard confinement rates, those rates for us also include children who have been abused and neglected that maybe need a higher level of care. They need a placement in a residential treatment center. When we look at those numbers, if you look at the petition, then that's going to tease out. We have a tendency to look at our system in the totality and look at out-of-home placements in general. And when we look at out-of-home placements, we look at how many of those placements are in a family situation. How many of those placements are in congregate care, which is a group home, a residential treatment center, or a psychiatric residential treatment facility. Or how many of those placements are at the boys' school, the girls' school, and then detention. So we don't spend as much time carving out the particular case in terms, is it a delinquent, is it a chins, is it an abused and neglected kid, but rather more about where are they and how do we get them home. Next slide, please. So, Mr. Chairman, we talk more in terms of Title 14, which are the juvenile court statutes. And those juvenile court statutes, what you see in the presentation today and what we'll talk about is really the application of policy as it applies to a lot of Title 14. And Title 14 is just the shortcut, but really it applies to any one of those petitions that get filed in juvenile court and then are heard and progress through juvenile court. As was mentioned by Mr. Fuller, there are multidisciplinary teams in place that are assigned by the court. Those teams then really case manage the case along with DFS. DFS takes a lot of responsibility in terms of its requirements to write the case plan, to monitor the case plan, and certainly our budget is what provides the funding for those services. But the process is real similar regardless of how you got there. Next slide. So these next slides, 15, 16, and 17, is just a little bit more information about the petitions themselves, the acts under which those cases are heard in juvenile court. So we can skip through those. And go right to the services and support. So once we have a youth or an adolescent in DFS and it has there's either a CHINS case or a delinquency case that's filed, we provide juvenile probation and supervision and case management. In our system, one, because of our size, and two, because of the way that we're organized, a lot of our workers carry combined caseloads, meaning they could have protective services cases, so families that are involved because of abuse and neglect, or they could have a couple of youth that are also children in need of supervision, and they can also have juvenile delinquency cases. Our larger jurisdictions have enough caseload that it makes sense that they carry an entire caseload of one or the other, but in most of our jurisdictions, we're just so small, it doesn't make sense in terms of resources to parcel it out. Juvenile probation can also be ordered to a county probation, and we have at least 2, possibly 3 jurisdictions that do their own probation for youth in juvenile court. Sweetwater County is one, Campbell County is the other, and possibly Sheridan County, but we didn't have time to verify that. Certainly, traditionally, it's been Sweetwater County and Campbell County. So when a juvenile court judge orders a child to probation in those 2 jurisdictions, the county then has the responsibility of supervising that youth, not the states.
Unless they're placed.
Unless they're placed. So there's another little of a nuance there. If a child needs to go into placement in either one of those jurisdictions, in any of the jurisdictions, then that child comes into DFS custody. DFS custody makes the arrangements, the children are placed based on whatever need. When the CSG was talking about a county-based versus a state-based system, certainly there's county probation in a lot of counties. And however that comes out through diversion or whatever that jurisdiction decides. But we do have a statewide juvenile probation system through DFS. The policies are issued consistently throughout the state, hopefully followed consistently throughout the state, but there is a statewide policy on the provision of probation throughout DFS. And that's a little bit of a distinction because when you talk about interventions through probation, there is a statewide effort. County to county will varies more at the circuit court level. In combination of children in need of services and juvenile justice, so those delinquency, that's about 33% of our caseload. 7% is adult protective services and about 60% are abuse and neglect. So that gives you a little bit of a feel for where our system really, who we're really serving. Independent living is a service that we provide for a lot of youth who are unfortunately aging out of care, meaning that they do not have a permanency. They've not been either reunified, they maybe have not adopted. And so older youth who are about to turn 18, that turn 18 without any parents or guardians. I think that's one part of the system that requires a lot of thought. And it really goes back to thinking about why children come into care. Because when children come into care, there's a chance they're going to leave care without a family. And we really, while we tried really hard to reunify, thinking very carefully about when we remove a child from a home, I think is important, regardless of abuse, neglect, CHINS, or juvenile delinquent. And then there's juvenile and family court supervised treatment, which is a program that's managed by the Department of Health, funded by the Department of Health. We participate, our participation varies on jurisdiction. Next slide, please. So the DFS placement and behavioral health continuum, and this is really I think the meat of a lot of what we've been talking about in terms of juvenile justice this past year. The Tennessee Watson through Wyoming Public Media has held a series of webinars, interviews, podcasts that really highlighted, and I heard it in the conversation when this came up as an interim topic, about our high levels of, at that time, incarceration rates. We call them placement rates. Not every child is in detention that's counted. Children that are counted in that, I think, are also children in residential treatment centers, psychiatric residential treatment facilities, and group homes. So it's not, I fear that when we hear incarceration, we think detention, and that may or may not be the case, but when we look at the system, we're thinking out of home placement, and in this case, probably congregate care. So our placement and behavioral health continuum is important. We have spent time with joint labor over the past year talking about this continuum, but it is the intersection of juvenile delinquency and CHINs with mental health and substance abuse treatment needs. And we play an important part in this. So what do we have in terms of services? We have outpatient settings. So for example, if we have a youth that's on probation, they're ordered to adolescent intensive outpatient treatment. They can do that through outpatient, typically provided by local community mental health and substance abuse centers. There may be residential settings. Those would be group homes, residential treatment centers. And basically, that's it in terms of a residential setting. Inpatient settings are restrictive, and they're either restrictive in terms of how you get in, the criteria, or the amount of intensity of the intervention. So an inpatient setting for an adolescent is a psychiatric residential treatment facility, a PRTF. Entrance into a PRTF requires a medical determination of necessity. So we work with Medicaid, and through Medicaid system, they do an evaluation of the child, determine if that placement is medically necessary. Then the child's admitted, and then Medicaid pays for their costs in combination with the Department of Ed that pays for education. Residential settings are group homes or residential treatment centers. And again, if you look at attachment B in your packet, you'll see the distribution of those services throughout the state. Next one, please. So why do kids go into placement? And then that's where the MDT comes in, really, is what does the child need? What does the youth need in order to get their needs met? There may be educational placements that occur. Those could occur outside of our system through education, but when they're through our system, we can place at a BOCES, which is a Board of Cooperative Education Services. It's another residential setting that I failed to mention. There are BOCES throughout the state. Then kids can get some intensive educational services, a lot of times though accompanied by behavioral services too. Some placements are behavioral. The behavior of the child, maybe as in a CHIN's case, requires a higher level of care than what can be provided in the community or by the family. And then the next slide. Clinical placements, those are the ones that there's a diagnosis, and then the correctional facilities. That can be detention, that can be the boys' school, or that can be the girls' school. These types of placements do not have a wide array of services in terms of mental health and substance abuse. They are not, children aren't placed there to get mental health and substance abuse treatment services, although children placed there may need mental health and substance abuse treatment. And I'll get into a little more detail about the boys' school and the girls' school in a minute. So a little bit about our budget then. How do we pay for these services? That goes back to how we look at our system. And because we use a child welfare lens, we're able to use federal dollars. So About 65% of the services that we provide to families involved with us are funded with general fund. We use those dollars then to leverage federal fund, which is about 35%. You'll remember a couple years ago, I came to you asking for some changes in statute so that we could continue to draw down federal funds. We're in the process of implementing those changes, and that's a little bit more of a different conversation, but this is why that was important to us. Title IV-E funding is a lot like Medicaid. You have to have an eligible family based on financial criteria, and the service has to be eligible for IV-E reimbursement. So it's not a block grant like TANF. It is a fee-for-service per family type reimbursement. And that's important because of our family first discussion, which is also the same. There's opportunity there, but it's a little more limited than we had hoped. And then we partner with the Department of Education and the Department of Health to pay for others, to pay for educational services and health services. So when we look at a placement in a residential treatment center, in a BOCES or a group home, we're talking about a 3-legged stool. Family Services pays for room and board, Department of Education pays for education, and the Department of Health pays for the medical costs. Next one, please. You can find that guidance under the court order placement statute, COPS, which comes up periodically. So moving on to the boys' school and the girls' school. So to be placed in either one of these facilities, there has to be a juvenile delinquency petition. This is one place where the petition really matters in order to be committed to this level of care. The girls' school is in Sheridan, the boys' school is in Worland. The charging and placement decisions are based on prosecutorial and judicial discretion. So who goes there? Again, recommendation to an MDT, and then ultimate order by the judge. And also ages 12 and up. Thank you. Children ages 12 and up. The majority of these youth are ordered to these facilities based on violations of their probation terms. So in a quick review of youth at the girls' school right now, over about 60% have been placed there because they violated a court order that outlined their probation conditions. Their probation conditions may include things such as go to school, don't smoke, don't drink, etc. A violation of any of those then is a criminal act, a delinquent act, and therefore then they are subject to placement at the boys' school or the girls' school. At these facilities, they both offer treatment, but they do that through local community mental health or substance abuse providers. So those providers come to the facility, provide treatment to the girls and the boys, some based on individual, some based on group, but it is not a therapeutic placement. The services that are provided by the boys' school and the girls' school have a lot more to do with things like, and this is an old term, but moral recognition therapy or criminal thinking. It's really about what is it that got the youth there, the delinquent act, and what is the action and the behavior, and is there opportunity to correct that behavior. The boys' school and the girls' school are both, they both determine when the course of stay is over and when the child or youth has successfully completed the regimen, then the boys' school and the girls' school determine discharge. Keep going through, please. Here's some specific information about the boys' school on 26 of your presentation. The 94 full-time was as of right now, as of July 1st, that number will be decreased. We made substantial position reductions to the boys' school and the girls' school. As a result of reductions in both of those facilities in terms of staff, we closed dorms in each location. At the girls' school, we don't anticipate any issues because they have their placements have continually gone down. So in some respects, it's a little bit of right sizing. At the boys' school, what we may see are increased wait lists, but they will be adjusting program to decrease the length of stay when appropriate. And that, Mr. Chairman and committee, is really where we tried to push through and summarize some of the larger document. But again, the LSO did a good job of really laying out the system. We just get to complement it with some of the services that we provide. The data question, there in your larger document, there is a list of the data that we collect through YCAPS, ROM, and what we report to the feds, so that you have some idea there what the department has. And then certainly a conversation about what we can do there to help the larger effort around data for all of the juveniles that are charged in the state.
Representative Yan.
Thank you, Mr. Chairman. And Director Schmidt, maybe this is a question also for the attorneys in the judiciary later on. Do you think that with the cut to the block grant for the Community Juvenile Services Board and resulting essentially cut to diversion programs, you'll end up with more youth in your custody in the future? because of it?
Director.
Mr. Chairman, Representative Yin, yes, possibly. What we don't know is a lot about those youth that were going through those programs. And so certainly the decision that's made by the prosecutor as to where that child goes, that level of detail. So it would be hard for us to really determine what the underlying reasons were for diversion. But certainly we expect that that is going to be a potential consequence.
Follow up, Representative Yan.
Thank you, Mr. Chairman. Director Schmidt, just a brief follow up. Do you think it would be useful for the prosecutors to record that data for you to be able to make policy decisions on where you cut budgets and stuff like that?
Mr. Chairman, Representative Yin, I think it would be beneficial to have a better understanding of all the kids. And whether we, specific data points may or may not be relevant for us, but certainly understanding more about any of the kids that are encountering the system through any type of citation or otherwise, yes, that would be helpful for us to make policy decisions.
Representative Washit.
Thank you, Mr. Chairman. Director, in your testimony and also in your handout, you referenced that many of the CHIN's petitions are being filed as a way to access higher levels of mental health care. Can you think of a better way, or is it ideal that these access to mental health care comes through a CHIN's petition? Or might there be a better mechanism for adolescents and youth who need mental health care to access that without a CHIN's petition, which entails a lot of time in the courts and so forth?
Mr. Chairman, Representative Washit, no, it is not our preference that that's how kids get mental health services. Certainly when it's needed and necessary, we believe in it, but we also don't want parents to feel like they have to give up their children to the custody of the state to get services. Back in 2008 or so, the Children's Mental Health Waiver, I think it was in place before that, but what the Children's Mental Health Waiver does is it gives access to mental health services to kids, not just based on financial eligibility. The financial eligibility is waived, but then they can access the Medicaid array of services, which then prevents children from coming into our care. So before that, there used to be children that would come into the care custody of DFS so that they could get those Medicaid services. The Children's Mental Health Waiver and the subsequent care management entity helped really reduce the number of youth that were coming into DFS custody because of it. So I do think that was a successful intervention. However, that's also something that it's another expense. And it was something that the Department of Health was proposing to reduce, but that reduction was reinstated. I do think that we have the best option is to reinforce our community services. So at the times of crisis, before you started to see a serious escalation of mental health needs in adolescents, that they can get that treatment locally. That would be the best.
Representative Lawrence.
Thanks, Mr. Chairman. We didn't talk much about rates for foster care and providers and resident treatments, but I'm wondering where those numbers come from on our reimbursement rates. Because I know Colorado about 3 years ago said the USDA recommends it's $13,000 a year to raise a kid. And so they reimburse foster families like $1,100 a month. And we just cut ours. It was going to be 6%, now it's still 3%. And I think the house all knows I'm a foster parent. So this does kind of affect me and my family. Not $15 a month, but it is, I get 6 emails a week asking to foster another kid because the need in Laramie County is so great. Can you just tell me how we're calculating our rates, and is there a metric or a basis? We just threw some numbers we're keeping with the last 10 years, and any way we can update that would be a fair way to pursue?
Mr. Chairman, Representatives Lonitzer, in 2016, the department cut its contract with Navigant that did regular rate studies. Basically, there was the big budget cut that happened in 2016. And the logic of the department at the time is we don't have enough money to raise rates. So why are we studying rating the actual costs, because we can't do anything about it. So that is my response. Certainly we could engage in a contract like that again, but it would result in the department coming back and asking for an exception request, which over the past few years hasn't been an option.
I wish it cost me $645 per month to raise one of my kids.
But they need a cell phone. Yeah.
Right.
It's not quite enough. Especially when they do mistakes. Sorry, go ahead.
I want to go back to Representative Yin's question to you about data collection. So the data, obviously, you have your own data points, but so I'm looking, for example, at delinquency placements. And so you're able to provide us with the data on the actual placement. Obviously, we would have to go to the source, the single point of entry, to understand exactly how many delinquents came before each county, each prosecutor. Obviously, that data is probably the most important data that we'll have on this entire topic, because if the number of delinquents that come before, there's I don't know, 498 is the estimated number in placement in 2020. And if, 10 times that number comes before our counties and our prosecutors could prove that number to us, then we're doing pretty darn good. But if, 500 came before and 498 ended up in placement, and obviously that's facetious, but the reality is without that data, we can't understand how placement versus diversion from placement is actually functioning. So my question to you, Director, is would your department be a logical repository for that data if we were simply to require the counties to provide that data? Would you be the logical place to hold it?
Mr. Chairman, this is a shameless plug, but you opened the door, so I'm gonna walk through it. We are looking at replacing our case management system. That's called YCAPS. We've been in the process for a few years, going through the legislative process of requesting study data to build the request for proposal. We are in a blackout period. We'll be releasing our request for proposal hopefully in a few weeks. But as part of that system, as part of the replacement of our 1996 case management system, there is opportunity to build modules. There's an opportunity to add on to that system with an additional cost. It's not something that's part of this request, but that would be a logical repository. But with data collection, the benefit is nice, but the work getting there is difficult. Data collection requires that somebody enter the data, and it requires that it may be entered into multiple systems. I don't know enough about the court systems, the IT systems that they have, to know what they can provide us as part of that. Our requirement, our federal requirement to replace our case management system says that we will interface with the courts, but we will be doing that through the Supreme Court, not necessarily through each individual district court, et cetera. We also will be required to interface with Medicaid and to interface with education. So once it is hopefully funded and built out, it will be a great repository for data. So it would make sense to add on some functionality, but it does require local participation and the local wherewithal to enter that information in, especially if we aren't involved, we being DFS.
Yeah, so there's two things for us to wrestle with. One, you having the adequate system to interface with those counties, collect the data, hold the data. That's the add-on to your YCAP system. And then the other thing we have to wrestle with is the ability of counties to, which we can talk to them about that, of course, too. So then, is the new YCAP system, it's not yet funded? It's partially funded?
Mr. Chairman, we were just funded to develop the RFP.
To develop it, okay.
Yeah.
But obviously it would be cheaper in the long run if you're going to add something onto it, I assume, just assumption that you would want to add that now rather than come back and add to it. Do you even know exactly what you would need to interface with counties and collect that particular data?
Mr. Chairman, no, we've not done an assessment on what the systems are and how that would work. What the approach that I'm suggesting, I don't even know if I'm encouraging yet, because we don't know a lot about it. There's just a potential opportunity that I think is worth looking into, but I don't know what the opportunities are for interfacing so that that data only had to be collected once rather than in multiple systems. It's a child welfare system. It's required per the federal government, so it comes with a lot of requirements around child welfare. But as I mentioned before, so many of the delinquents in the state that end up in juvenile court are in that system anyway. Another plug, and again, I'm probably getting ahead of myself, but another plug is in response to the Council of State Governments conversation about consistent application of structured decision-making or an assessment tool. There are modules available where that information around risk assessment, et cetera, can be gathered, and then that assessment information can be used for a determination. So it does create another opportunity for consistent data collection of risk. What local communities do with that data, again, is the question that you brought up, and certainly one to struggle through from a policy consideration. But the capacity to provide the tool is there.
It's not as easy as Representative Oakley just sending an email once a month with here are the number of cases I charged, unfortunately. Or is it, Representative Oakley?
Thank you, Mr. Chair. No, this is, to me, seems like the nuts and the bolts of it. Sit here and talk for 4.5 hours, talking about data collection till we're blue in the face. And I'm trying to figure out the what's in the house of implementing it. So is it currently the YCAP system that you use? What is its deficiency?
Mr. Chairman, Representative Oakley, I don't know where to start. First, it was built in 1996, so we have policy analysts that are younger than our system. And when it was really built around a specific purpose. It wasn't built to collect data in a way that you can really mine it, analyze it. We report on it, but the structure of it is very antiquated. So when we think about analysis now, and we go in, there's a lot of ways that you design the system to be able to facilitate that. That's not there. It's written in an old language, so we always have concerns that the people who support it, the great people at ETS that support that system, are going to leave ETS, and then we're going to have to look for somebody else who can speak in that kind of coded language. And there's many other things that at the end of the day, it's antiquated and it no longer meets our needs.
Representative Oakley.
Thank you, Mr. Chair. So follow up, because it sounded really good what you were starting to say. And then you said, I don't know if this new system would be where we would be able to do this data collection. So you're looking at a system, what you're talking about implementing is for DFS, but you are unsure if it can be used for what we've been talking about here, trying to figure out what's happening with our overall juvenile justice and what's happening with, I guess, specifically the juvenile justice, because you're saying you do it through a child welfare lens, so it might not apply to what we're talking about as far as this juvenile justice information.
Mr. Chairman, Representative Oakley, the reason you hear my hesitancy is because we've not looked into the technical aspect of it. So we didn't design the system thinking entirely about those kids that show up in circuit court, for example. But there is flexibility in designing the system. And so I guess I'm a little bit kind of hedging my bet so that I don't go out and make a promise that I really can't back up until we can look at it. There are juvenile justice modules out there that we can interface with. I don't know what kind of data they collect, if it's the data we want to collect. I mean, that's going to be some conversation that we'll have to have, is we can build out, a lot of different ways of the system, but what is it that we want to know? From a DFS perspective, we know what we want to know. The federal government helps us with that, and our practice helps us with that. And that's going to include kids that are juvenile delinquents, adjudicated juvenile delinquents. Again, it's that front end that I'm not so sure about. But we could certainly look into it. We could investigate it. I know there's been some preliminary conversations about this when this all came up, to say, wow, is that something that we could build into our new CCWIS system? And that's the acronym the feds give us. It's the Comprehensive Child Welfare Information System that will replace Whitecaps. But one, we're not funded. And two, this conversation about data has just started more recently. So we haven't given a lot of the mental attention probably to answer your question point blank.
I think it's worth trying to look at, because all of this entire morning that we've spent so far, in my mind, boils down to 3 questions that you have to answer, that we all have to answer. Number one, how many juveniles come before our justice system? And that data you don't have. And I suppose we would have to bring every prosecutor in the state of Wyoming in front of us to probably get that data point, and we would struggle to get it, because the answers would be, I don't know how many cases I have. I just have a lot of cases. And so that data, that's number one data point. And then number 2 data point is, how are they diverted? And if they're not diverted and they're placed, how are they placed? You provide us with that data. And then dovetailing off of that is everything CSG said, which is, are they in the right placement? Were they in the right diversion? And then the 3rd data point is simply recidivism. Did it work? Whatever, whether it was diversion or placement. And so, I mean, that's what this is all about, is we can't without that data. And so we need to find, I think in my mind, we need to find a central repository on where we can begin to collect this data, so we can begin to understand it and so we can address it. And if we are building a new YCAP system because we're building it for entirely different reasons, and there's an ability for us to attach onto it, I think that's worth looking at. Representative Provenza.
Thank you, Mr. Co-Chairman, and thank you, Director, for the information. You mentioned that the girls' school has that 60% of them that are there on probation violations. And so one point I want to ask is, do we know what it is for the boys' school? And a bigger question is, what's going on with probation? Are we setting children up to fail so that they end up back in? Or is our structure not serving them in a way that rehabilitates them? Just any insight you have on that. And then as an additional kind of tack on to that, when we have an average length of stay of 7.5 months at the boys school and 8.9 months at the girls' school, what is the cost of that? And how does that cost differ from community diversion programs?
Mr. Chairman, Representative Provenza. So can I answer the last one first? The cost is fixed. The amount of the budget is fixed until we reduce it. So the cost per child is going to change depending on the census. And so yes, it's going to probably be sometimes more expensive, less expensive. And then the length of stay really is somewhat built around some of the educational provisions and then some of the therapeutic, and I shouldn't say therapeutic because it's not mental health treatment, but the treatment approach and in progressing through that treatment approach. So that's a pretty hard question to quantify. We do not have the information from the boys' school, but we can get that. And then I think the second question was what's going on with probation, and what is happening that we see the result of a probation violation and then a placement at the boys' school or the girls' school. And I think that's a conversation that we can certainly look into. We don't readily have that data, but we could dig a little bit more into it. Again, the decisions though are made by the multidisciplinary team. So that body is providing recommendations to the judge. So they're looking at a whole host of information related to the family, related to the youth, his or herself. And so there could be a variety of reasons for it.
Okay, one last question before we go to lunch, and that's before Co-Chairman Nethercott hits me with this gavel because we're not at lunch. I want to drill into the placement data, because you said during your presentation something that's very accurate, but I think we have to understand what it means. And that is that all of the youths in placement in Wyoming aren't necessarily incarcerated or in detention. So we need to drill into that number, I think, to really understand it. So I want to make sure I'm looking at table 11 on page 23. I want to make sure I understand the different facilities then, so I can get a better number of who's in a detention or incarceration type placement. So obviously I know what jail means. That's obviously incarceration or detention. Boys' school, girls' school, it's residential placement, but I would consider that detention. And tell me if I'm inaccurate. And I don't know what detention is. Number 3, detention versus jail. What is that? What is detention versus boys' school, girls' school, jail?
Mr. Chairman, detention versus jail, there's juvenile detention facilities and then there's jail.
So far we can put on the placed in the facility list, detention, boys' school, girls' school, jail, and then group home, residential treatment, no. Foster care, depends on the foster parent. Just kidding, Representative Swanister. Psychiatric RTC, that's residential treatment. Is that placed in a facility, right? And then obviously not parent placement, independent living, nope. Hospital, that's probably more temporary in out before they end up somewhere else. Runaway, what's runaway? That's what it means. Okay. I wasn't sure if it was some crafty name for a facility. Yeah, what my kids say every day.
That'd be bad marketing, Mr. Chairman.
It would be bad marketing. State hospital. Okay, that's placement, obviously. So, and then foster care and interim. So I have 221 of those placements in a detention incarceration type scenario. So some of the 498, that's probably more fair or accurate representation.
Yes, Mr. Chairman, but any youth that's placed, that DFS is paying for is court ordered. And that goes to somewhat the conversation about confinement, meaning that the court has placed them there. I think you could have some discussion, and I imagine there will be some discussion this afternoon about what exactly that means. But Again, our lens is really looking at out-of-home placements.
Okay, so like, because a group home could be court ordered placement.
Yes, Mr. Chairman.
I guess just in my, anecdotally in my mind, I assume it to be a better place than jail, but. Okay, so we can drill deeper into that data. All right. Well, with that, I think we'll break for lunch because that's the end of your presentation, right?
Yes, Mr. Chairman.
Yep. Okay. We still have more to come on juvenile justice. And we have more scheduled for the afternoon. When we come back, we'll be speaking with the State Advisory Council, the Prosecutors Association, and then we'll go into public comment. Wrap up this topic. So we'll go to lunch. I noticed you only scheduled this for an hour. Clearly, you haven't seen me go to lunch. But maybe we can, I don't know what our Representative Washut, is that going to give us enough time if we come back at 2 in Casper? Because of the road, and I'm thinking about the national college finals that occupies a lot of the.
Right. Some of the restaurants are not open, they're dining rooms.
Cheyenne is open.
We'll shoot for 2.
Shoot for 2. We'll come back at 2.
We'll hope for the best. See what happens.
Okay.